So had, there have been a number of inputs in terms of public course, number of inputs around the cyber crime bills, its contents, and how the bill as drafted can uh, can result in the abuse of these laws, and abuse from the perspective of suppression of public discourse, terms of violation of human rights. So I just want to start my presentation just to present a few uh, um, headlines which shows from around the world, what type of abuse has occurred. And these are headlines from the last 12 to 18 months. As you can see, there have been issues with abuse of cybercrime laws in Jordan, in Thailand, Pakistan, Egypt, Philippines, India, Senegal, a number of different locations, and it ranges from targeting and victimization of opponents of public officials. It ranges from digital rights abuses in terms of internet shutdown to prevent persons from expressing themselves or expressing a discord or disagreement with the government. It ranges from attacks on individuals in terms of spyware, disproportionate mass surveillance of individuals. So I just wanted to use this as a bit of the backdrop for my discussion. I had submitted a number of different comments. I discussed illegal access. My perspective for in terms of illegal access is there are a number of legitimate uses of so-called access in terms of testers, researchers, activists, whistleblowers, which actually serve the public good. So I just want to be sure that you can understand that specific impact. Particularly, a big concern is that we have a lack of trained uh, court officials, and we don't have a specialized court. Speaking of this in terms of specialized court, for example, the UK has the King's Bench Division on technology, which has specialist judges, which are known as masters, who have special and training to address and adjudicate these type of matters to make sure that innocent or well-meaning persons are not imprisoned. This particular section on modification of programs or the data, this is particularly important because it's misaligned. It's not present in the Budapest Convention, the Commonwealth Model Law on Cybercrime, the Malabo Convention, or any other of the cybercrime model laws. This is actually an outdated term, and it also uses outdated language, and it criminalizes a number of modern productive use cases for modification of software and data processing, whether it be artificial intelligence, free and open source software, open data policies, and creative commons in terms of modifying and sharing data, permission granted to modify and share data outside of the normal authority of the person who has created that program or data. This section particularly is an unnecessary session, and my recommendation is that it should be removed. It can be addressed by Part 2.6, which should be actually changed to interfering with data to better align it with the Budapest Convention. Interfering with program or data, that's Part 2, Section 6. This again uses outdated language, and it should really focus on somebody that has intentionally, without authority, and causes harm. If something is temporary or not, and doesn't cause harm. It shouldn't particularly be a crime. Criminalizing minor acts, especially acts that don't have any harm in terms of public good, individual harm, corporate harm, is unnecessarily criminalizing individuals. Same thing with part 2.7, interfering with a computer system. This is another particularly concerning section in terms of poor legislative drafting. And it really doesn't address the true criminality, which is really, again, focused on intention without authority and seriously hindering the functioning of a computer. And many of the laws, including the convention, focus on seriously hindering serious harm to ensure that minor infractions are not criminalized. Illegal interception of the data, which is part 2.8. I wanted to focus on this section because interception of public information, and this is why I particularly to talk about the lack of understanding of modern computer systems and data management. Because usually one of the foundation of the data management is classification. So if data is classified as public, sensitive, confidential, strictly confidential, if data is public, why should someone be in charge for interception of the data that is publicly available? I think that's a misnomer, and you should really look at if the intention is dishonest, if the intention is harmful, and if it's the intersection of non-public information. The misuse of the devices, I've mentioned this in my submission. I want to particularly refer to the Budapest Convention, which says that misuse of devices, illegal access, interfering with a system, all of these should not be interpreted as imposing criminality, and not for the purpose of committing an offense where it is authorized testing or protection of a computer system. So where there's legitimate use to protect a computer system, to ensure a computer system is robust and resilient, these type of laws should not be used to criminalize those practices. The critical information infrastructure section, which is part 2.12. My concern with this section is that really and truly this is unnecessary for a cyber crime bill. It's already being addressed in multiple different sections of the bill. What you really need to do is to create a separate critical infrastructure protection legislation that focuses on obliging critical infrastructure providers to implement strong cybersecurity measures and making sure that you're monitoring and ensuring that those measures are in place. That goes a lot further than in terms of protecting our critical national infrastructure than a kind of symbolic section about critical infrastructure.
Mr. Harper, just wish to inform you, you have 2 more minutes.
Yes, I know that.
2 more minutes.
And I just want to stop a bit as well, just to reinforce. We've had a number of people submit for 2 hours, 5 hours of public submission, and an actual expert, you're restricting their submission to 10 minutes. I think that's a bit unfair. With that being said, malicious communications Again, this really focuses on on, on criminalizing to a large extent, which is just normal discourse, online discourse. Another a key thing is the Budapest Convention and other model laws do not address malicious communication. Also, trying to treat the cyber crime bill with criminal defamation is very, very problematic because the European Court of Human Rights, the United Nations, several human rights organizations, as well as intergovernmental bodies maintain that criminal defamation laws are an unjustifiable affront to human rights. Several progressive nations have actually removed criminal defamation laws from their books. The section on cyber bullying as well. Adults are supposed to be resistant to hurtful words. If you look across progressive nations, cyber bullying laws focus on schools, children and adolescents. They don't focus on adults, and when they do, they're particularly restricted to violence acts, sexual abuse, and harassment. Search and seizure, I've already mentioned all of these other things in my submission. I just want to go to the last part. We have a problem in Barbados with capacity and building. We don't have a national strategic cybercrime capacity building approach for training the law enforcement, prosecutors, magistrates, and judges in terms of making sure that they have continuous development, that they understand existing and emerging technology, how those technologies interact with the law, and to ensure that they have the right knowledge and skill set that they can actually administer these types of cases when they do come in front of them. So that being said, I will stop. I'm here and I'll take any questions.
Thank you, Mr. Harper. Any committee members wish to raise any issues which Mr. Harper has presented in either his written or oral submissions? Okay, let me ask then. Mr. Harper, in your written submission, you criticized, well, Section 9A and 9B. Let me just get them under misuse of devices. And you can correct me if I am misunderstanding you, but the section speaks to for the purpose of committing an offense. All right? Person who intentionally or recklessly and without authority for the purpose of committing an offense. That's Section 9A1, for instance. Section 9A2, same thing, for the purpose of committing an offense. So wouldn't you agree with me if I were to argue that hence the use of this device for legitimate testing and protection of computer systems would not come within the prohibitive ambit of Section 9? Because obviously, if you're using it for legitimate purposes, as you have argued, comes within the criminality of that section, you would not be using it for the purpose of committing an offense.
So, just to be clear, offense here is a very nebulous term. It's not properly defined in the bill. In many places, what are offenses? Again, are normal interactions with human beings online. there are other legitimate uses in terms of accessing programs, remixing software data, addressing or using computer systems without the permission or the authority of the person who created them or the person who is licensed the software. So what exactly is an offense? Because you've defined a number of offenses that in the real world are not actually offenses. So my position was that if you don't properly define an offense, or if you don't train your magistrates and your judges to understand what these actual offenses are, then you run the risk of criminalizing what is not an offense and fining or imprisoning someone unjustly.
But Mr. Harper, I will want to argue with you that we have separation of powers in Barbados, as you know very well, separation of the judiciary from the legislative body. And Parliament cannot go into detail and define every single word in every single act. There has to be a role for the judiciary. And that's the judiciary's prerogative to say whether it's an offense or not. That's my argument, sir. And I'm speaking as a lawyer for 40 years too. There has to be a role for the judiciary in this. What I would agree with you, sir, is that the judiciary, therefore, we need to ensure the judiciary is well trained in it. As for example, as I understand it, in September, when there was a 3-day seminar here, which Sir David would have mentioned in his submissions, oral submissions, the last time we met, judiciary was invited as well. So I think your stronger argument is that, yes, we have to ensure that the judiciary is well trained on this issue, but to say, sir, that Parliament should usurp the role of the judiciary and tell the judiciary exactly what is the definition of an offense is, etc., leaves, in my opinion, infringes and usurps on the independence of the judiciary, which is a fundamental concept of our system of governance and our laws.
So my response to that is, first thing, a 3-day workshop, which I'm very familiar with those workshops that are done by the Council of Europe. That's not the training. That's not education. It's this course on best practices and protecting the human rights, etc. That's not training. I've trained for cyber crime law, cyber security, privacy, and other similar matters for the last 20 years. And we ensure in our field that there's continuous education, 20 hours, 40 hours, 60 hours, 80 hours per year, continuous education to ensure that as technology shifts and you see emerging technology, new technologies which affect crime in different ways, that you stay in touch and you better understand so you can administer these laws again. So yes, you're right, they should be trained, but I also want to say this. I'm not saying that the separation of powers should be usurped, but if you look at, again, progressive nations, they have explanatory notes explaining in detail what are our crimes, how to understand the difference between the acceptable use and criminal use. They have the guidelines, they have white papers. These are administered along with the laws to serve as guidelines so magistrates and judges can better understand these subjects and make sure that they're administering the laws in the right way.
Thank you, Mr. Harper. So at least you seem to have conceded that in terms of the legislative provision, there's nothing wrong, but obviously in terms of the administration now of the law, that, well, the government, and that's different from the legislature now, has to try and ensure that there's proper training in terms of the administration of the law. Your
So just to be clear, my submission very clearly says that there should be training. So should be some type of note or training that make sure that your magistrates and your judges understand the law. So there's nothing to concede, because I think we're on the same page.
In terms of your criticism and comments on Section 12, the categories of critical information infrastructure system, and I'm reading your written submission to say that this should be dealt with in regulations as opposed to in a parent act. Well, that's a matter, I think, for the legislative drafters maybe to advise on, but the categories of critical information infrastructure systems should not and cannot be closed. And I think we all accept that in terms of evolving society and governance, just like how categories of negligence, a judge once said, in case law can never be closed, categories of critical information infrastructure system cannot be closed. And therefore it would be contemplated that subsequently that this category would be widened. So what is your comment on that?
To address that, so I was very particular with my recommendation. So if you look at the United States, the European Union, if you look at India, Bangladesh, other countries, Sri Lanka, and I'm very familiar with those countries because I have developed their capacity building. I've trained their judges, their legislators, etc. They have what are called critical infrastructure legislation. What that legislation outlines in detail what is critical infrastructure. It outlines what you need to have in place as a critical infrastructure provider in terms of cybersecurity requirements, computer security incident response. It puts obligations by law on critical infrastructure providers that they protect their critical infrastructure of the nation. And they also create a government department that their job is oversight of critical infrastructure providers to ensure that those strong cyber security measures are in place. And what I'm saying is that goes further in protecting national infrastructure than criminalizing access and unauthorized access to critical infrastructure, because the majority of the persons who are going to access your critical infrastructure and do you damage are not in Barbados. They're people in Eastern Europe, in North Korea, and these are people that will obscure their locations and their identity online. So you can't even bring those persons to justice. So what I'm saying, instead of focusing on a symbolic and a useless clause, you should focus on implementing laws that actually protect your critical infrastructure.
And my final query to you, Mr. Harper, relates to paragraph 11. Paragraph 11, section 11, disclosure of access code, where you've been critical of this section, and it is arguable, it is certainly arguable, I want to concede that section, subset 1 and subset 2 of section 11 is that they are duplicitous, and that one could perhaps be eliminated, as you seem to be saying. Which one you would eliminate if given the choice?
So it's not even a rich one. I think that whole section is not a useful section. That's not present in, if you look at any model law or treaty, that's not that's not addressed, because there's so many normal use cases and non criminal use cases for disclosure of access codes. You use shared codes when administering systems. You use shared codes when you're doing the encryption. You use a number of different shared codes, and sometimes it may be without formal authority. It may be interpreted as reckless. At the end of the day, this is not treated as a cyber crime in Malibu Convention, the Commonwealth Model Law on Cybercrime, as well as the Budapest Convention. This is just not addressed. I don't see a reason for this section.
Mr. Harper, Ramel Spring here, and I read your written submission, and I must admit that when I first read that bit in the legislation, it did flag up some concerns for me, and I think I raised it here during our initial discussion. At least I intended to. You're saying that basically that, and I caught that when I came in and I heard your oral submission, that we're basically criminalizing trivial matters, and this would almost, and that's me paraphrasing your words from what I understood you to be saying, and this in a sense is a trivial matter, and that there are many normal usage where persons may inadvertently disclose access codes, passwords, and so on and so forth. But the legislation speaks to A, the reckless disclosure, and B, it also speaks to, I guess, disclosure or gaining access to these codes, passwords, and so on for unlawful gain. They're using that to I guess, to earn or to gain money unlawfully. I'm assuming that there's in most cases, that's the reason why people engage in things. And working in a ministry where data is so critical, data is so important, I can't see a scenario where there's not a piece of legislation that looks specifically at situations where persons, because of the clearance that they have in their jobs, in the areas that they work, may not necessarily be listed as critical. I mean, I don't know if the CIA Licensing Authority, for example, is listed or seen as part of the critical infrastructure. It may very well be, but there's a lot of important data that is stored, or persons who work within that department has access to, that can be sold on the market. And I believe that persons, if given that level of clearance and engage in any kind of unlawful, reckless disclosure of that information, whether it be names, codes, passwords, what have you, there should be something in the law that gives the authorities some sort of recourse. And if you were to remove this section altogether, then I think, I mean, of course, there are other ways that persons could be prosecuted, but I think that this here gives us more direct authority in terms of how we would treat the persons who engage in that type of behavior, that type of criminal activity. So if you can speak to using those types of scenarios that I just placed there on the table. Of course, there are other situations where I don't believe that a person who, because they work for me and have access to my password, to my computer, or anything like that, that if they share that password or tell somebody that password, I obviously would want to see that person being fined $25,000 or 3 years in prison. But I would want that there's some sort of legislation to protect me from even the person thinking about that they can share my information on IG.
Okay, so this
social media platform.
So just to be clear, you have quite a number of sections that address that. You have you have illegal access, you have misuse of devices, you have interfering with a computer system, you have interfering with data. Like, I mean, part of my concern, again, there are a number of redundant sections in this bill that serve no purpose except as to confuse magistrates or judges, especially the untrained ones. Again, I want to circle back to this is not treated in any other law. This is actually a holdover from our Computer Misuse Act. And if we're supposed to be upgrading the Computer Misuse Act, my 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 interpretation would be that you would streamline the law, make sure it's better aligned with international treaties, especially when you're looking or you have expressed an intention to accede to the convention, or when the United Nations has finished the discussions on their cybercrime law, which aligns very much with the convention, then you're going to end up not misaligned with international and treaty and international law. So why not just at this point, when you have the opportunity, just remove a section that's not aligned with international law that serves no purpose, is already addressed by several other sections.
Are there any other members who would wish to engage Mr. Harper? No? Okay. In which case, Mr. Harper, we thank you both for your written and for your oral submissions. We can assure you that we will consider them with the authority and weight that they deserve to be considered. We thank you.
Much appreciated.
Okay.
Thank you as well.
Okay. Next up, we have Mr. Stephen Williams, who is here present with us. So, Mr. Williams, we invite you to come forward. Romel, let him sit down. Let him sit down there. Yeah. No, where your bag is. Yeah. Once you don't mind, so that he can face. Good afternoon, Mr. Williams.
Good afternoon, sir. Good afternoon, members of the subcommittee.
You are here pursuant to your written submission to this committee, which is examining the cybercrime bill and the mutual assistance in criminal matters amendment bill, both 2024. And you gave a written submission in your capacity as consultant to the cybercrime bill, you said. And you could explain exactly what you mean by that. And we've invited you to give a oral submission of no more than 10 minutes on your written submission. So you need not repeat what you've said here. In your written submission, you could emphasize and clarify and expand, but we have already read your written submission. And after you're finished, your 10 minutes max, we will open the floor to any committee member who wishes to engage you on either what you've written or what you've said orally here today.
Thank you. Good afternoon, honorable members of the Parliamentary Subcommittee. Thank you for granting me the privilege, and it is indeed a privilege to speak to you today. I would also like to express my gratitude to the chairperson of the Law Review Commission, Sir David Simmons, for selecting me as the IT consultant to the cybercrime bill. I'm honored to contribute my perspective towards refining this essential legislation. Approximately 12 years ago, I was a victim of a malicious and defamatory lie published on a then popular social media platform. It falsely accused me of being a drug dealer who stole money from the government, a blatant and disastrous lie. because that platform and content creator was located outside the jurisdiction, coupled with the limited scope of the 2005 Computer Misuse Act, I had no legal recourse to seek justice for the defamation I endured. This new bill is a significant improvement because it incorporates international assistance in criminal matters, ensuring that no one can hide behind geographic locations to carry out malicious attacks. Unlike the 2005 Computer Misuse Act, which was mostly confined to domestic crimes, the new bill aligns with international conventions providing a framework for effective cross-border collaboration. As a former member of Parliament, as a former member of the Board of Directors of the Transport Authority, I saw firsthand fraudulent documents submitted to the board, falsely claiming to be authored by the then chair and granted permission for various licenses and clearances. These documents, which use computer technology to misrepresent the board's actions, aim to deceive and exploit the system with the inclusion of offenses related to computer-related fraud. The new cybercrime bill gives the police a strengthened tool to pursue individuals who engage in these activities. This empowers them to investigate and prosecute those who manipulate digital information, safeguarding the integrity of organizational processes. The cybercrime bill represents a comprehensive effort to establish a legal framework that tackles from the threat of cybercrime itself, child exploitation, to the misuse of digital devices. However, as with any forward-looking legislation, concerns has arisen by various stakeholders, which I now turn my attention to give my perspective. Illegal access provisions. With regards to the broad definition of illegal access provisions implicating the idea that it's implicating cyber professionals and activists, the linchpin, and something I will consistently reiterate, is it's up to the judiciary to discern between malicious intent and authorized actions. It's not customary practice for cyber professionals to illegally break into a network or computer system without proper clearance. And I say again, it is not the actions of a cyber professional to break into a computer system or network without clearance. Regarding activists, even actions performed with good intentions or altruistic goals have consequences. The judiciary must determine the difference between those with malicious intent and those whose actions, albeit well-intentioned, could cause significant harm. Critical information infrastructure systems. The scope of CIS should be dynamic and inclusive to address emerging digital services. Currently, the bill focuses on public utilities and government functions, potentially minimizing, unfortunately, the critical sectors like food and chemical production facilities. It is crucial to promptly publish complementary regulations that ensures regular updates to the CIS listings and incorporates evolving technology like artificial intelligence. Using the term critical infrastructure systems, however, instead of what is in the draft bill, which is the critical information infrastructure systems, broadens the scope to include both physical and digital systems, such as transportation, energy, and healthcare. This comprehensive terminology ensures that both physical and digital systems receive adequate protection, recognizing that disruptions in one can affect the other. Moreover, it will help encompass emerging technologies such as AI and the Internet of Things. This adaptability would enable the bill to effectively protect all sectors vital to national security and daily life, aligning with international frameworks that broadly include essential services and systems. Malicious communication. Like the defamatory lies I experienced, require strong safeguards to protect potential victims from unfounded and unwarranted attacks. This includes maintaining firm measures against those who intentionally or recklessly use computer systems to intimidate, threaten, violence, or defame others. However, it's essential that these protections strike a careful balance, ensuring that the judiciary discerns between malicious intent and legitimate public discourse. This approach allows us to protect victims without stifling free speech, creating a digital environment where people can share opinions safely while deterring harmful behavior. Disclosure of access codes. Under Section 11 of the proposed cybercrime bill, disclosing a password, access code, or other means of addressing a computer system without authority could technically lead to legal consequences, including imprisonment of up to 3 years or a fine of 25,000. However, whether sharing, for example, a Netflix password with a third party would specifically lead to such penalties is a matter that requires careful
I
interpretation.
beg your pardon, Chair. And through you, I know Mr. Williams has been given a time limit.
Have I gone over it, sir?
No. And we're losing a lot of the meaning as he rushes through. So through you, I'd like to encourage Mr. Williams to slow down so that we understand what he's saying. Don't rush through it at the expense of us losing the meaning, because I want to follow you.
Okay.
So, Chair, may I ask through you that Mr. Williams slow it down. Don't worry about the 10 minutes. If 15 isn't going to kill anybody. And let us follow the minutes.
Chairman, I also suggest that if he has speaking notes, he may want to share them with us after as well. Because I think Mr. Thorne may have lost some.
Two valid points. So you can make speaking notes available to us. But like I said, you can expand ad lib on anything you are saying.
Sorry, I can certainly slow down on behalf of the panel. Thank you. Under Section 11 of the proposed cybercrime bill, disclosing a password, access code, or other means of accessing a computer system without authority could technically lead to legal consequences, including imprisonment of up to 3 years or a fine. However, whether sharing, for example, a Netflix password with a third party would specifically lead to such penalties is a matter that requires careful interpretation. As a consultant and upon reflection, I wonder if this provision would be more appropriate for corporate disclosure of passwords rather than domestic sharing, which could be seen as a civil matter. I leave the decision to the honorable members of this committee. However, if it remains as law, it's essential that courts carefully weigh intent and harm to distinguish everyday behavior from genuinely unauthorized or harmful activity. In conclusion, I wish to leave the committee with 3 points. Intent. It is the core of this legislation rests on the concept of intent. Just like a knife's purpose is judged by how it's used, so too should actions in cyberspace be equivalent by intent, evaluated by intent. Parliament defines what constitutes crime. The judiciary determines whether such acts have occurred based on evidence and intent. Symbiotic regulations. This new law relies heavily upon complementary regulations that dynamically update the list of critical infrastructure services and establish criteria for those qualified to assist the Commissioner of Police with digital forensics. These regulations are urgently needed to supplement and give teeth to the legislation itself. Password sharing. While sharing passwords for personal use may be considered unethical, whether it's a criminal matter or civil matter deserves careful deliberation. My concern with this provision in its current form is that it criminalizes everyday behavior, which could lead to situations of possible entrapment or abuse. Thank you for your time and attention on these points. I hope that the points will help shape your decision to strive to create an effective, balanced, and fair cybercrime legislation.
I thank you, Mr. Williams. Now open to committee members to raise any issues with you relating to what you've said, what you've written, or to the bill in general. Senator Cruz.
Thank you, Chair. Through you to Mr. Williams. I listened with intent to your presentation, and I was making some of my own notes. And you did make a comment that Mr. Harper made before, and something that I believe that I shared in our inaugural meeting, and which is in terms of the executive's capacity, when I say that exactly, state to issue guidelines and regulations. Citizens must know when they're going about their affairs, whether they are engaging in activity that is unlawful. And when there's uncertainty as to unlawfulness, that creates a legal problem, because then, whether somebody is acting unlawfully then becomes an arbitrary exercise It should be an objective one. So that we don't have normally state issuance of regulations and guidance, as is in other established countries around the world. In this cybercrime era, we see a lot of guidance being issued. What is, in your view, our capacity to do so, and which arm, or not necessarily arm, which part of the executive? Is it to be a new arm to be created? Is this to be a specialized body that would need to be created? Who should comprise that body? Should members of the public have access to it, to lobby, to help form and shape the regulatory content that comes out? To what extent is the prosecutorial discretion to be guided by these regulations? And how do we, as a legislative body, the ultimate maker of the law, rein in any excesses that may occur to the disadvantage of the public? Thank you.
Thank you, Senator. It's a very detailed and comprehensive question in terms of where do we go from here after the bill is passed in whatever form. You are right, and if it's any agreement with the previous presenter, is the fact that this bill needs regulations. How it is governed and executed is a $64 million question, because right now, I mentioned areas such as those who will have capacity to assist the Commissioner of Police. We need regulations to determine what those qualifications look like. In terms of the critical infrastructure list, that is something that's always evolving. Under the current proposed bill, a list of services have been named. However, that under the international standards and framework, for example, NIST, which is an international standard by the National Institute of Science and Technology of these states. Transportation, so take, for example, have electric buses, right? The possibility is there that, with the right training, some person can attack electric bus because it's digital. So therefore, if some person was to attack the electric bus grid, God forbid, right, and disable the bus, we can basically disrupt the everyday life of Barbadians. So we need, to my mind, we need not just regulations, but we need an authority to basically assist the minister in their actions. The way the ministry is structured right now is not structured to be a proactive and research-based arm for evolving, I guess, technological trends. Normally, the ministries in previous years, to my knowledge, relied a lot on, I would say, ad hoc input from the private sector. So yes, we need an IT authority.
And since Steve and I have known you to be an expert in this field, like Mr. Harper, for a long time, there's the view that discussion in cyberspace online is necessarily free and it is a public discourse, but a lot of these platforms are not necessarily very public. They're very, what's the correct term?
Closed systems?
Closed networks are owned by private individuals who will develop the algorithms and the various mechanisms to steer and stir debate in certain directions. And the public believe that these are free, open networks and so forth. The one that I might be participating in may not be the same one that you are participating in, or you might not be having access to the same information because it is being generated based on a perception of what we might like to see. So that, how do you perceive that we can properly regulate this environment? This is all the tech geeks, no offense intended, the domain of people who are techno-savvy in these areas and stuff. But for those of us who happen to like a good spy movie or the modern movies with all the technologies and the investigations going on using cyber resources, how do we cope with this environment? I mean, the legislation is the first natural step, and to what extent, after we pass the laws, are we necessarily going to be able to detect cybercrime and also to be able to protect people from it?
Thank you. I think that before we have that authority, we have to determine exactly what we want to do. Because, for example, the police needs additional resources. I met a wonderful chap in the police force that is a forensic specialist, but they also need other arms of the police force. We don't necessarily, truthfully, Barbados has had a very rough time accepting the transition into the digital era. So let's look at your point with how then do we go forward with, I don't want to use the word policing, but let's say, supporting, monitoring, and building out, right, capacity for governance in terms of this cyberspace and social media space. Part of it comes down to, and I like what Barbados has done over the past concerning the social partnership. So there's a role for government to play. There's a role for the unions to play in terms of ensuring that citizens and the members of unions have representation on, for example, an authority to make sure that their interests are served. But more importantly, we do need civil society on a whole to participate. And what I've seen consistently is that there are few people who understand the problem and then put squarely the entire problem at government's feet. And I think that that's part of the problem because government only has so many resources at its disposal, but yet social media and social governance is everyone's problem. I think that what government can do is provide a framework and an authority for people to actually feeding those concerns too. I think that is the next logical step. But how is that authority structured should be something that is desirous of consultation. But I do believe that even though if we do that, there's still limited, I guess, governance that we can have because we are not the owners of the platform. Classic example. You will find that within recent times, if you put up a post that's okay under the cultural sense of Barbadians, that YouTube, or it's not YouTube, Facebook may find it offensive. Certain words we use every day may not have the same cultural impact and significance as Facebook. These platforms have their own cultural norms and they have their own policing mechanisms that have nothing to do with Barbadians. And then there are things that are Barbadian that are offensive to us that these platforms don't flag. But yet we have no control over them because there's not a Barbadian, there's not a central authority. And unless you become like China, have the great firewall of Barbados where the government is policing everything that goes in and out, which I don't ever want to see, then it is incumbent upon third parties, including the government, to be active, to play an active role in ensuring that whatever law is passed feeds back into a mechanism that governs the country digitally.
Honorable Leader of the Opposition.
Thank you, Mr. Chairman. Mr. Williams, I ask very short questions. I don't make a speech here. So I'm going to ask you some very short questions. Do you see your purpose here as that of either supporting or opposing the bill? Let me ask again. Do you consider that it is your purpose here either to support the bill or to oppose the bill?
I'm here to support the best possible bill that this Parliament can craft on behalf of the Barbados public.
I take it that's a yes. You see your role as being here either to support the bill or to oppose the bill.
I'm not opposing any cybercrime bill.
Precisely.
Right.
So you're supporting it.
Yeah.
Right. Now, were you a consultant prior to the drafting of this bill?
I was a consultant to Sir David Simmons pertaining to the bill, yes.
You would admit then you come with a bias.
I come with a perspective to...
No. Were you a consultant towards the drafting of this bill?
Yes, sir.
Therefore, may I suggest to you that you are unlikely to oppose something to which you are a consultant.
I guess that has known to occur, but...
Beg your pardon?
I guess that's known to occur.
Yes. So you're agreeing with me that you are unlikely to oppose something, drafting of which you were consulted.
But I don't oppose the bill.
I know you don't oppose it, but I'm asking a different question.
Right.
Do you agree with me that you are unlikely to oppose something to which you were a consultant?
Fair.
You agree with that?
Fair.
Good. All right, we've established that. So you do support the bill?
Yes, sir. Go ahead.
Yes. We can make this short, you see?
Okay.
Now, I was reading your conclusion, and one of the reasons I asked the chairman to ask you to slow down was because we were losing, well, I was losing a lot of the meaning, and I wanted you to slow down. You wrote a conclusion here, and I was trying to read it while you were speaking. And you said, let me read the first two lines for you. The effectiveness of the Barbados Cybercrime Bill hinges on the ability of the judiciary to discern the intent behind the actions of defendants in cybercrime cases. Now, if you read the other 4 paragraphs coming after that, in your conclusions, you do make repeated reference to the judiciary. And you seem to be placing the responsibility on the judiciary in its effort to interpret that which you assisted in drafting.
Yes, sir.
Together with the judicial responsibility, do you consider that Parliament has a responsibility? Prior to judicial intervention, do you consider that Parliament has a responsibility to do that which is just?
Of course, sir.
Thank you very much. Those are my questions.
But can I follow up on that, sir, if you don't mind?
Yes, well, if the chairman allows.
Sure, Mr. Williams.
Sir, of course. But in my humble opinion, it is Parliament's decision to determine what crime looks like.
I see. So the question then, do you consider that no, as we agreed, you focused on the judiciary,
Yeah,
but I've taken you to Parliament, which acts before the judiciary.
correct. Yeah, I understand that, sir.
And do you consider that Parliament, in the drafting of this bill, has done its duty entirely in terms of promoting justice?
I think the draft of the bill, well, the reason why we're here is that it's not, I agree, it's not a perfect piece of legislation.
It's not perfect.
It's not perfect, and nothing will be perfect.
No.
Right?
You said it's not perfect.
It's not perfect.
Don't worry about other things. You're saying that this bill is not perfect.
No, it's not perfect.
Okay. You're going on the record. You know this.
I understand it's not perfect. In my record too, I also said that, for example, critical information infrastructure systems.
So there are areas of this bill that you think need improvement.
We're in a subcommittee, that's why we're here. We're here to improve what is there.
So I'm asking you a direct question. Are you saying that there are areas of this bill that require improvement? If it's not perfect.
It's not perfect, and just like I mentioned that area, I think that we would get to a more perfect bill when we deliberate these sorts of.
Where we have this kind of
discourse.
Yes. Yes, thank you very much, Steve.
Okay.
Okay. We're not fighting.
Yeah. Sometimes you don't even know what it looks like.
Thank you, Chair.
Chair, can I? Yeah.
Sure.
Mr. Williams.
Senator Walters.
Mr. Williams, you were speaking quite swiftly earlier, but did you also say that you were also a victim of cybercrime at the beginning?
I was not a victim of cybercrime because it didn't occur under the law. It did not fit that definition of cybercrime. But in terms of some person basically tarnishing my reputation, I was a victim of some person tarnishing my reputation, sir.
So I guess the lawyers here can, and Mr. Thorne, you can guide us here as well. In the public domain right now, people are saying that we have the Defamation Act, which sufficiently deals with defaming of a person. Sanctions in terms of that. How did you seek legal recourse through that Defamation Act?
The person did not reside in Barbados. The person was in North America. I will have to get some other thing to say that our defamation laws extend to the United States in terms of that fits that bill for defamation in the other states. Then when we look at how the current Competition Misuse Act did not necessarily extend that far to say that one can go after what may be occurring under a digital sense in another jurisdiction. So whether defamation would have occurred is a good point, that I may have some recourse under that. The fact is that it was a cross-border issue, and there was no cross-border implications in the last bill, in the current Computers Misuse Act, which means that would be a weakened position from that perspective. And at the time, the social media platforms did not necessarily see themselves as being governed by certain laws as well.
Thank you, Chair.
Mr. Williams, the bill as presently drafted has been criticized by some as being an unreasonable limit on the constitutional right of freedom of expression. And I want to say freedom of expression because that is what the Constitution says, and not freedom of speech. There's no constitutional right to freedom of speech in Barbados, as there is, I believe, in the United States. And of course, that right, as defined in the Constitution, is curtailed, as is every provision within those sections of the Fundamental Rights Act of the Constitution, I believe, sections 12 to 23. What would be your response, if any, to the criticism of this bill as presently drafted, that it infringes unduly and unreasonably the constitutional right to freedom of expression?
Mr. Chair, I don't think so at all. I think under this bill, I think the intent is to do harm to an individual. Now, for example, child grooming. If you look at the rights and freedoms of an individual, is it a right that a person will go and groom a child to do something adult-like? I don't think so. But we have a lot of thoughts in terms of rights and freedoms, but I may have the right to do something, but I don't have the freedom of consequences for my actions. So, no. In terms of malicious communication, a person who intentionally or recklessly uses a computer system to publish, broadcast, or transmit a computer data, right? And we know what it says here. So if the intention is to hurt someone, why should I have the right and freedom to that? If I want to express myself, if I want to now share my thoughts on something, that's perfectly fine. But if I'm going to take up a computer system or digital system to personally attack someone, to defame their character, I give you a situation of me, right? Where I have never been associated with that type of action that hurt my character. And everyone in life just has their character, sir. So therefore, if some person can take up and hide behind a jurisdiction to attack someone, the difference is, you may say, Steve, well, people know that ain't true, man. The difference is, when you publish it on the internet, if there are 10 people that know me, there are 2 billion people that do not. And by doing so, if the intention is to hurt me, why should I not have recourse? A law can make some person guilty. It is the judiciary that finds if some person is guilty or not. You could bring actions against some person who you think hurt me, but I still have to prove the case in court, sir.
Are there any other comments from members?
Yeah, Mr. Williams, when you, in your submission, when you were speaking to section 11, you suggested that perhaps this section should be treated, or at least there should be some category that speaks to commercial versus domestic misuse of access to codes and passwords and so on and so forth. I think that was a suggestion that you made. If you can expand a little bit on what you meant and why you believe that should be domestic and not exactly what you just described, where a person would have defamed you overseas. That too could also be seen by some as non-commercial and could be domestic as well. So if you could.
Okay, in relation to the disclosure of codes, you have Netflix, everybody kind of shares like Netflix password, or sometimes people have a particular site that they go on, they know in dealing with children, sometimes they know they go and share their passwords for gaming sites.
Before you go any further, Mr. Williams, remember the bill speaks to recklessly, intentionally. It also speaks to unlawful gain. You're doing these things for unlawful gain. You're not just doing it because you have access to the information. There's an aspect of the section that speaks to unlawful gain. So you cannot dismiss or divorce that particular aspect from the bill, from that section.
And fair enough, and that's why I said, to me, some aspect needs regulation. Because, so can you see? Right. A person who intentionally or recklessly blah, 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 gain access, I'm reading strictly here, right? And I'm not seeing unlawful gain. Maybe I misread it, sir. Into. Right, but one stands on its own. This 11.1 stands on its own, sir. There's another provision for 2. So 1 on its own speaks nothing but gain. If 1 linked to 2, fair enough. But 11.1 stands on its own, sir, as a specific treatment. Right? 11.2 stands on its own as a specific treatment to the offense. So on its own, that's why I said it's up to this chairman to determine such actions, but this is where regulations will come into play. Because I do take your point. There are certain situations where it may not even be the corporate sense, but some person now uses for unlawful gain to, for example, sharing passwords for commercial purposes. Right? But I think that speaks to intent. But that's where I'm thinking regulations is needed to this specific act. Because with regulations, it can now start to have that nuanced perspective. That's why I said to the Honorable Opposition Leader that the bill isn't perfect. What will make the bill more perfect is if you have regulations quickly to this act, so some of these nuances can be further identified and vetted. Because left on its own, it may be okay, but in the sense where you just brought up where, for example, it's unlawful gain, where I decide to share my password for money. So I decide, you know what? All right, I got a Netflix account. I can sell my Netflix account for $5 to 3 friends on a weekend. All right, that's unlawful gain. I don't have the right to do that. All right, but regulations now would determine to me, all right, instead of being so granular, I don't want a granular bill. Because if you have a granular, minutia cybercrime bill, then we're going to be back at this again next year, or another 2 years from now when technology has changed. So we do need to have a situation where regulations come extremely quick for a bill like this, sir.
Yeah. Or you're going
No, just to summarize that, I believe Chair would have said that we perhaps will have to look at this section with the view of conflating it, and I think you were suggesting that we probably reject the entire section, and some of what is listed should fall under the regulation. So I take your point. I just want to thank you for your response, Honorable.
Thank you. Thank you, MP Springer. Mr. Chairman, just one short question again. Mr. Williams, in answering Senator Walters, you made a very interesting comment. You cited the example of an offender overseas against whom it was difficult to find a sanction. And now you speak with the authority of a consultant, and I want to ask you if a major focus of this bill is the pursuit of persons overseas whom you can't otherwise capture.
Sir, can you rephrase the question again?
Yes. In answering Senator Walters, you cited the example of a person who may have defamed you, and that person is overseas, so that you can't pursue that person in terms of defamation of character lawsuit. And you referred to the usefulness of this bill in going after that person when you consider that it goes with the mutual assistance legislation. I want to ask you as a consultant, and you do speak with the authority of a consultant, and therefore you'll be persuasive as to the content and intent of the bill that's before the House. I want to ask you to say to the public if then a major focus of this legislation is the pursuit of persons overseas who are offensive against Barbadians living here. If that is a major focus of the bill, the pursuit of persons who are overseas who may be otherwise difficult to capture by a defamation lawsuit.
Every aspect of this bill was looked at. I don't think there's any one specific area that had more attention, honestly. I think given the fact that, and you would appreciate, sir, that when we had the Competition Misuse Act, there was no social media. When we had the Competition Misuse Act, there was no such thing as social media, right? Especially in its current form. And therefore, the interactions with what was people over, or what is people overseas versus being able to actually get there to get attention. So basically have the local thing, as you say, attacking locals or whatever, wasn't thought of. So in drafting a modern or updated bill, we have to look at every aspect of what crime, right, would constitute for Barbadians to protect Barbadians from crime. Part of that, sir, is to ensure that we had jurisdictional assistance. It's just not saying that we have a lot and go after some person, but the reverse is also true. There are people in Barbados who may be involved in crime here, and then from an overseas perspective, there's a judicial arm on the other end that may want to get information on what's happening here. So we can't get one without the two. It's not a one-way bill, right?
But my question to you is whether in the drafting of this bill, is the overseas person a major focus of attention? As opposed to a local person gossiping and that kind of thing.
No, sir.
Is the pursuit of the overseas person a major focus? That's a yes or no?
None from any
So
meeting
that
I was in.
the bill
No.
intends equal pursuit in relation to overseas as it does against
Yes.
locals? Yes.
It is the protection of the citizens of Barbados.
Yes.
Whether
Whether the person is overseas or here.
or whether the person is some person overseas and not even a Barbadian, once we have a jurisdictional relationship.
Yes.
So the person not even have the Barbadian connected to Barbados, if you harm Barbadians and you're overseas.
So the pursuit is equal.
Correct.
Right. So that if you have a person here committing the offense, this bill intends to go after that person with equal intensity, equal force.
I believe so, sir.
Thank you. So that anybody can be charged.
Anybody can be charged, but not everybody can be convicted.
Precisely. You're back to the judiciary again. Would you agree with me? Last question, sir. Would you agree with me that based on the content of this bill, these offenses are likely to be committed every minute of every hour of every day? You're a social media man and an expert, not in committing the offenses, but you pour over social media, and you would agree with us that these offenses are committed according to this legislation, almost every second of the day. Every new opening of Facebook, you will see an offense being committed. Is that not correct?
I would say every second of the day. What I would say is that there's a difference between
All right, let me put it differently. This could become the most frequently committed criminal offense in Barbados if this bill passes. A story comes out in the paper, for example. We see it all the time. Some incident they're reporting on, and then the comments that come underneath it. The insults, the offensive language, the defamation. Don't you agree with that? That this bill will create the most frequent criminal offenses in Barbados?
Sir, I would say that harassment is against the law of Barbados.
aware of that.
But what I'm trying to say is that,
asking you-
but what I'm
asking
trying to
you
say
if
to you,
I'm asking you if, according to the content of this bill is going to criminalize, I think we're all agreed here, that this bill will criminalize many areas of speech. We're all agreed on that. I'm asking you if, as an expert and a frequent visitor to social media, especially Facebook, wouldn't you agree that this bill, if it becomes the law of this country, will create the most prevalent state of criminal offenses in this country?
no. Let me say,
Okay.
and let me explain. The intent is where I hang my hat.
I'm talking about content, not intent. Content. The content of this bill will create several criminal offenses across social media every minute of the day
How?
by people insulting others, by a story coming out and on any incident on which the press reports, you see it's Mr. Williams, people gather underneath that story and call the person all kinds of names, a fraud, a thief, all kinds of things. And I want to suggest to you that those fall within the definition of criminality within this statute. I know you agree with that, but what I'm asking you is if this will not create several offenses across social media every minute of the day.
Okay. And I take a deep breath for this one.
Well, it's a yes or no.
No. It's not yes or no,
Oh,
sir.
I beg your pardon.
It's not yes or no. Because even in life, all right, people use, and I like to quote Dame Billy, muscle words against some person. All right? Which may be against the law, but it's passed because the intent, even though might kill you, man, I'll walk along. That in itself may be an offense in our law, sir. You're the constitutional man. You know whether that is an issue or not. But is it pursued by our justice system? Probably not. However, I go back to what I see happening with young people right now, right? Where the cyberbullying, because the part of the argument is that this is the same language is used in cyberbullying. There are many young people who use those words who do not have the mental separation to not take it offline. And part of the law's ability to say, well, look, let's look at the pattern of behavior. Because a lot of these fights that happen in secondary schools right now, you can ask any school principal, is that they start online with violent language and violent intent, and then it basically escalates. If we can use this law to stop it at the violent online behavior before it escalates to some person getting killed, I'm all for that, sir.
So you are agreeing with me that the offense will be committed quite often? At the end of it, would you agree with me, Mr. Williams, that this bill, this act, this law will create offenses quite often when you consider that young people and old people and middle-aged people spend much of their time on social media commenting, saying things that are offensive every day, all week, all month, all year?
Sir?
The question I come to, I know you agree with me, but what I come to is the question of who selects and how is the selection done in terms of who will be charged. And I think that is a concern that the public will have. Because I know that all of us in here agree, I can open social media now and I will see several insults being uttered. Who determines which one to charge? That is what the public may be concerned about. Who determines? You can't answer that. It's not intended for you to answer. That's a statement.
But I understand.
And that is what the public is concerned about. With all the offenses committed across social media every minute of the day, the public is concerned as to who will influence a prosecution. It is as serious as that.
But sir, let me say that.
It's not for you to defend, Mr. Williams.
No, but I have to say.
We don't think you're going to influence any prosecution.
Right, no, hold on. It's not necessarily influencing prosecution. But don't I have a right to face my accuser? If I feel that a crime has been committed to me, right, and I get your point, right, because ultimately the DPD is going to have to determine if there's enough evidence warranted under this bill, right, based on what has transpired online, and can enough evidence be gathered to determine if it would be actionable to carry it to a court of justice. So I understand you may think that it creates the opportunity for crimes to happen every minute or every day. But the fact remains that just a one-off statement might not have that, because I could bring nuisance claims, and you're a lawyer. A lot of your clients bring nuisance claims, wanted a defense, but they do not carry over to a judge, sir.
All right, we're not arguing, we're not disputing on that.
Mr. Williams, just want to address a couple issues. In your written submission, you said that the definition of cyber terrorism should be expanded. Can you comment further on that?
In terms of cyber terrorism, I take the point, and I think I would like to withdraw that statement. I know I submitted to the department, but I would like to withdraw it. On further reflection, I can say why. It's linked to our anti-terrorism bill. And my concern was by not having it defined under the umbrella of cyber, that it might not necessarily include certain types of actions, just like how, for example, we speak strictly to information, critical information infrastructure. At the time, am I thinking, and I reflected on it, maybe it can be broad enough if you're going to refer to the anti-terrorism bill. My concern, though, if I still have one, is the fact that we do not know what shape or form terrorism is going to take under cyber terrorism. And once again, that's why I withdraw it with the hope that there are regulations to this act. Because whereas it may stand as adequate under terrorism under the Terrorism Act or the Anti-Terrorism Act, I am uncomfortable to think that where we have the Internet of Things and we have AI, that the actions of someone where it can be artificially generated, I'm not sure if it's going to cover it. But if you have regulations that can speak to it, then I'd be a little bit more comfortable with that. So, sir, Chair, I withdraw that complaint with the hopes that we do have regulations that help shape some of the nuance that is outstanding in this.
Thank you for that, Mr. Williams. Two more issues. Section 11 of the bill as drafted presently. Can you have it with you? Right. Subsect 1 and subsect 2 seem, at least could be interpreted in some way as repeating themselves with each other. What would be your comment on that? And if you were to eliminate one subsection, which one would you eliminate or advise to eliminate?
Could you give me a quick second to just...
Yeah, sure.
I suspect there's a subtlety here, sir, but I cannot put my finger on it. What I can say is that if it is left in, if either of these two inserts are left in, my concern would be the judiciary's interpretation of it, meaning that if I share a password and some person feels that, you know, in doing so, I broke the law and brought a case against me, and the DPD was to have a very strict interpretation of the law. Under 2, I could be facing 7 years in prison, of which it doesn't seem to say if I'm a repeat offender. I thought 2 was going to speak that if I repeated the offense to 1, which is normally the case where you strengthen the first version with the second. So this looks like more like if the language may speak, if I I'm found guilty under one, and the person who continues to do it again may find a lengthier term imprisonment, as usually the case. So like with critical infrastructure, if I break into something once and I get slapped with a hard fine, but I do it again, it means I'm a repeat offender, so therefore the charge is double. In this particular case, I would get rid of 2.
In this case?
So in this case, I would get rid of 2. If you have to leave 1 back, I would get rid of 2. But I'm sure there's a nuance in here that I'm not seeing it. I'm not a lawyer, sir, so forgive me if I'm not seeing it with the legal eye, define subtleties of these 2 particular paragraphs.
My last intervention with you, Mr. Williams, relates to section 19.1a, the issue of the intimidation aspect, which appears to be criticized by some as to intimidating a person and, well, intentionally or recklessly through use of a computer system, but that can be criminalized. I know that the Guyana section as well is similar but not the same. And I'm wondering if you would wish to recommend any amendment to that section, that subsection on the issue of intimidating a person.
Sir, I think that's a politically identified, because I can give a perfect example where it should be left in. There are situations where young women are being intimidated online of not doing something. Classic example, this is an example, I'm not bringing up a specific case, but if my daughter is bringing a case against an individual, and that person is a well-known person within society, and people get to social media to intimidate her to change her mind, does it not fit this definition in its current form? If, for example, a person gets online, all right, and realizes that, pretty girl problems, all right, young people get online, all right, and intimidate the person. You don't go into this so-and-so competition, blah, 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 and things happen and pop off, and intimidate that person not to participate in an event, not to participate in a sport. Does it not fall into that definition where the person uses a computer system to intimidate another? I think the hullabaloo is from a political sense. But I don't think we can sit down here and draw a line in the sand over politics versus anything else. You can't determine, you can say, well, this is okay unless it's in a political sense. I think that's part of the problem. So if we said with a little bracket, excluding politics, I don't think anybody will have a problem with this statement. Well, unless you're going to define it, all right? Because I don't think anyone will have a situation where their girl, child, or son, or member of their family, all right, is getting intimidated via social media, via networks, and you think that should be allowed. I think the problem is that politics got involved, sir, and then people see it from a political lens.
Let me just follow up on my question. Section 19.1 of the Guyana Act says a person commits an offense if the person with intent to compel another person to do an act which the other person is not legally bound to do, or abstain from doing an act which the other person has a legal right to do, uses the computer to publish, transmit electronic data that intimidates the other person. That person commits an offense, subject to criminal law. In other words, the Guyana section expands a bit on it by speaking towards compelling another person, seeking to compel a person to do an act which is not legally bound to do, or abstain from doing an act which the other person has a legal right to do. Whereas our proposed section is general, just a person who intentionally or recklessly uses the computer system to intimidate, guilty of an offense. So I'm just wondering, do you think there is reasonableness in preferring the expanded Guyana subsection on this issue?
I can't break it down to a yes or no question, sir. Reason being is that, for me, there's certain suggestions that were made under regulations, and this is not one. You're asking if the intention of this particular section can be expanded and not weaken the whole entire, the entire law itself, because each section builds on the other. For example, this particular malicious communication, right, strengthens the cyberbullying, or reiterates the cyberbullying section. I do not know if we take out some or expand upon it, it's going to weaken any other part of the legislation. So I'm saying that maybe it's a good argument, but I'm not a lawyer. So for me, what I would say under malicious communication, the intimidating a person, using a computer system to intimidate someone, I take your point. Well, they have gone and defined it, right? I'm always in favor of broad law where possible, right, and regulations where practical. So for me, that is one that I do not have a straightforward question. I wish I can give you one, sir.
Okay, Senator Walters.
Mr. Williams, as an IT consultant feeding into the bill, what specific technical or expertise, IT policies or framework has been feed into this bill? Because we hear a lot, and you use the term very often that you're not a lawyer, but it's not to personalize you, but even from a consultant, an IT consultant person, what are the specific areas of expertise within the IT world that has been fed into this bill?
Okay, so take for example, within this particular bill, it refers to things such as how ISPs will be involved, all right, things like traffic data, what they will provide to lending assistance to the police. I think from my perspective and where I lend assistance is in terms of how things may be practical. So that's why I said coming out with the regulations, leaning towards regulations, because to be helpful to this bill, we'd need regulations. So for me, areas of this bill speaks to anything dealing with how technology might be impacted, or how people might be impacted with technology. So I didn't get a write a piece of legislation, but I maybe ask questions in terms of how would technology impact this bill. So is this practical? And for me, I'm always for broad-based legislation, because we ain't coming back to this. In 2005, we ain't come back to this for another 20 years. So for me, I would say if this piece of legislation is in here, this may be how it looks like in 5 years, given where technology is going. So section by section, my responsibility was to ensure that it stood a reasonableness in terms of the time that it would be valid for. Or if it is a technical term, such as traffic data, right, how would that impact basically the legislation in terms of carrying out certain functions, in terms of what has to be given up in terms of the information. If you have to hold on to, for example, going back to my organization, if I'm required as an IT person to hold on to data, all right, how long we hold on to data for, what that should look like, these types of things that will impact a case. Because for me, I really like to see some regulations, because there was a case called, let me give you my example again, right, where it was a situation with a client of mine. I had to hold on to his hard drives. So how long you have to keep the data for, what condition it might be in. So there's certain questions that the chair would have referred to me and say, well, Stephen, what does this mean? You know, would this be a situation technically that we have to worry about, right? Those types of things. So it's not that I had a hand in writing the law, but being an advisor to the technical aspects of the law.
Okay, we thank you, Mr. Williams, for your input. You can be assured that both your written and oral presentations will be considered with the weight that they deserve. So we thank you for coming before us this afternoon. Okay. Before we proceed, committee, to invite Mr. Anthony Green to come forward, I'd like to, I think in the interest of transparency and accountability, I need to respond, and members just pray my indulgence, to some comments made, attributed in the Nation newspaper of April the 25th to a Mr. Caswell Franklin on the legitimacy of this committee. Mr. Franklin, in that article, is quoted as saying that this committee is reflecting on the cybercrime bill, contrary to the standing orders of this parliament. And he queried how Sir David Simmons should know the standing orders of the House, and that the standing orders of Parliament do not allow this monstrosity. He's quoted as saying that they have called a joint select committee. The article continues to quote Mr. Franklin, who, of course, was a former member of the Senate, as saying that the Joint Select Committee is a creation of Parliament. It has never happened in the Westminster system before, where a bill is passed in the lower house, it goes to the upper house, and the upper house then forms a Joint Select Committee. It is contrary to the rules of the House, because once the House has passed it, the House cannot go back into committee on that bill. The House is not going back into committee on the bill, but a few of its members are sitting with senators on a joint standing committee. The Joint Standing Committee, Joint Select Standing Committee, and I have the standing orders which establish this committee. The standing orders say that the joint standing committees are permanent oversight committees established at the beginning of each new parliament and continue to function until the dissolution of the parliament. Standing committees are permanent committees established by the standing orders of the House. They are mandated by the House to oversee a government department or departments, to review particular areas of government policy, or exercise procedural and administrative responsibilities related to Parliament. Some committees may have both departmental and policy area responsibilities. In addition to the permanent mandates provided to standing committees by the standing orders, other matters may be routinely referred to them by the House for examination, bills, estimates, documents in the House, tabled in pursuant to statute, and specific matters which the House wishes to have studied. A House may refer specific studies to committees by adopting a motion to that effect. The motion, once adopted, becomes an order of reference. Further to the subject matter of the study, the order of reference may also contain conditions that the committee must comply with in carrying out the study, or additional powers which it may require for that purpose. Mr. Franklin is alleging that the bill, having passed the lower house, and it goes to the upper house, where the House forms a committee. The Senate did not form this committee. This committee was formed under these standing orders by both houses of Parliament, formed a joint select committee. In fact, the Parliament of Barbados formed 3 joint select committees. This one on governance and policy matters, a second on economic and productive sector matters, and a third on social sector and the environment matters. The House formed these committees, the lower house, on the 2nd of May, 2023, and the Senate formed them on the 17th of May, 2023. Standing Order 48.1 of the Standing Orders of the Senate empowers the Senate to commit a bill to a select committee, which is a fact which Mr. Franklin in the article acknowledges. The Senate has so committed this bill to this joint select committee, which has been established by Parliament. So the issue of Mr. Franklin asserting that the bill having been passed in the House, then if the Senate had problems with it, the Senate could identify these problems and send it back to the House, or they could have formed a committee of the Senate to investigate the bill, is not relevant here, does not apply. This government, by forming these committees, is committed, as expressed in the Charter of Barbados, on the passed in the Parliament of Barbados on the eve of our becoming a republic. It's committed for the development of active citizenship to deepen the effectiveness of our democracy. And this is what this process is about. Furthermore, it is an accepted tool of parliamentary law that the House can regulate its own procedure, known as exclusive cognizance. Exclusive cognizance, simply put, is the right of each House to judge the lawfulness of its own proceedings. And Parliament has exercised its right, the exclusive right of the two houses to make and vary their own rules of procedure to protect the legislative supremacy of Parliament. And that is what has been done. The Senate of Barbados on the 16th of February 2024 passed two resolutions which have sent these two bills to this joint select standing committee. And by doing so, it is fully within its right to do so, fully in terms of the law, fully in terms of the standing orders and regulations and powers of the Parliament of Barbados. And this is simply a way of trying to improve the functioning of Parliament, which is, of course, ultimately the forum for the people of Barbados, and allowing the people of Barbados to have a say as they choose and as they wish, either verbally, orally, or both, before a subcommittee, a standing committee of this Parliament made up of members of both houses of Parliament. And I must say clearly, advice has been taken in forming these committees, these three committees, and specifically this committee, by clearly the learned Attorney General, and we have on this committee the Honorable Leader of the Opposition. I am chairman of this committee. All persons who have been called to the inner bar, long-standing lawyers, and we take the advice as well of the Clerk of Parliament, who is a very experienced clerk, being clerk of this Parliament for years. So I just felt that in the interest of transparency and accountability, I couldn't let what Mr. Franklin is reported to have said go without a response, because he's effectively said that this committee has no legitimacy. And I wish to publicly respond and refute that charge. Mr. Anthony Green, we invite you to come forward and to give your oral submission. Welcome, Mr. Green. You are here this afternoon before us, and we thank you for accepting our invitation to come, because you submitted in writing that you wish to give an oral presentation before this joint parliamentary standing committee on cybercrime bill or the mutual assistance in criminal matters amendment bill. And we're allowing you no more than 10 minutes, sir, to give your oral submission. After your oral submission, committee members will be invited to engage you, either by comment, questions, any clarification we need for whatever you say. And, you'll be invited to so respond to committee members.
Okay, thank you very much, Chair, and good afternoon to the members of the committee. I am thankful for the invitation and the opportunity to present. I must say, though, that the timelines were very tight, and that's why I opted for the oral presentation. And just to state that I've not necessarily come to address matters specifically relating to the content of the bill, especially given the limitations in preparation for the presentation, but just to make a presentation in relation to the general spirit of the bill and the perceptions that have arisen out of the debate of the bill. And I want to begin by saying that communication lies at the heart of everything that we do. It serves as the conduit through which ideas are shared, decisions are made, and progress is achieved. And as such, it is imperative that we carefully evaluate our national approach to information sharing, ensuring that the environment we cultivate fosters transparency, inclusivity, collective goal setting, and participation. And with the introduction of the Barbados Cybercrime Bill, we are presented with an opportune moment to reflect on the manner in which we communicate in our country. Our communication strategy should not only facilitate the dissemination of information, but also empower individuals to actively engage in shaping the future of our country. And I know that I only have 10 minutes, so I have a lot to say on that, but I'm going to skip to the meat of the matter. First, I just want to say that as we implement the cybercrime bill, I think it is important that we be careful to avoid stifling freedom of the press and freedom of expression, or I should say the perception thereof. And there's a need to strike a delicate balance between protecting individuals from cyber threats and upholding the principles of transparency and accountability in governance. We must guard against the perception that the cybercrime bill is aimed at restricting the flow of information or fostering a culture of secrecy, and instead approach its implementation with a nuanced understanding of the complex interplay between security concerns and democratic principles. And I do agree that with the advancement of technology, we really need to ensure that our laws, our legislation, and so forth are up to task in terms of dealing with what we currently face. Now, back in 2017, the Center for Law and Democracy, CLD, posted on their website concerns about the cybercrime bill in Trinidad and Tobago. And the article stated that when it was first introduced, the cybercrime bill was heavily criticized by media and human rights organizations, including CLD, for vague and overbroad content offenses, which would have prohibited a range of innocuous, normal, or even beneficial online activity. And despite some minor revisions, the current version of the cybercrime bill still suffers from these problems, according to them. Now, Michael Carr-Nicholas, Senior Legal Officer of CLD, is quoted as saying that overbroad content offenses are always illegitimate, but are particularly dangerous online, and where many people are still in the process of discovering their voice. The bill, if passed in its current form, could have a substantial chilling effect on online speech in Trinidad and Tobago. That article also states that some minor improvements have been made in the latest draft, the bill in Trinidad and Tobago we're talking about. Notably, the deletion of Section 7, which prohibited the illegal interception of information. Now, interestingly, we also have a similar reference in our bill the illegal interception of data in Section 8. We note that that section in Section 7 in the Cybercrime Bill in Trinidad and Tobago was deleted. I again refer to the article which draws up concerns in other sections and says that in each case, the prohibitions are so broad that they include perfectly legitimate online activity. And furthermore, the Cybercrime Bill creates a presumption of criminality for expressive activities which are undertaken without lawful excuse or justification, shifting the onus on users to demonstrate that their actions are legitimate. This type of reverse onus runs contrary to international freedom of expression standards, which only allow states to prohibit limited and clearly defined conduct. And this problem is compounded by the fact that the term justification is unduly vague. Now, very quickly, sections 8 and 12 are particularly problematical insofar as they essentially make it illegal for journalists to receive leaked information including from whistleblowers. Leaks often serve as an information safety valve, performing vital public functions. For example, by drawing consumer attention to a defect in a product. And even when it is reasonable to sanction those who breach a computer system to obtain information or share information beyond its authorized recipients, journalists should be allowed to receive and report on the information they receive without fear of retaliation. And I will add, so long as the journalists or media personnel are acting in the public's interest. And this is definitely core to the work of media. So then that it is not just in Barbados that concerns have been raised about matters relating to such a bill, but there are legitimate bodies, individuals, and professions that have seen, that have reason to flag real potential conflicts as a part of the national discussion on this bill. I want to quickly move to the fact that the Media Institute, and before, let me just state my recommendation, because this is one of the main reasons I chose to make the presentation. There is one thing that I think would help us to address the concerns and perceptions against the Cybercrime Bill. And I now make this recommendation with a view of gathering greater support and buy-in for the Cybercrime Bill. It appears to me that there is support generally for many of the issues raised in the Cybercrime Bill. The concerns center mainly on freedom of expression. But truly, we are missing a very important piece of legislation that addresses many of the concerns raised around this Cybercrime Bill. That important piece of legislation is the Freedom of Information or Access to Information Act. The responsibility is being placed on individuals in relation to how they communicate online, and in some instances, rightly so, but government also ought to shoulder some of this responsibility for how we communicate by creating an environment where access to information that is in the public's interest is fluent, timely, and unhindered. The Media Institute of the Caribbean, MIC, just last week, released a Freedom of Information and Access to Information Legislative Review Report, and it specifically looked at the English-speaking Caribbean. In the presentation of this report, it noted that not every country in the English-speaking Caribbean has Freedom of Information, FOI, or Access to Information, ATI legislation. The countries with the laws in place are Trinidad and Tobago, Freedom of Information Act 1999. Belize, Freedom of Information Act, Revised Edition 2000. Jamaica, Access to Information Act 2002. St. Vincent and the Grenadines, Freedom of Information Act 2003. That it's been passed, but not in effect. Antigua and Barbuda, Freedom of Information Act 2004. Guyana, Access to Information Act 2011. There are issues with that one. Bahamas, Freedom of Information Act 2017. Cayman Islands, Freedom of Information 2021. That was a revision. St. Kitts and Nevis Freedom of Information Act 2018, amended in 2023. That's the list. There's no Barbados on this list. Barbados is at the back of the pack as it relates to freedom of information, access to information legislation. And we need to come to the front. Where are we? Barbados has drafted a Freedom of Information Act, but has never enacted it. The same is true of St. Lucia and Grenada. Under the section general comments of this MIC report, there's a special note of the Regional Agreement on Access to Information, Public Participation and Justice in Environmental Matters in Latin America and the Caribbean, the Escazú Agreement. And this regional treaty creates benchmarks for FOI and ATI legislation. Interestingly enough, it addresses environmental matters, of which Barbados, as we know, is up front and center, and rightly so, and doing a good job in addressing those matters. But this same legislation addresses benchmarks for FOI and ATI legislation. Some states in the region have signed the agreement, while some have both signed and ratified the agreement, thus creating obligations for themselves. Let's look at that list. Those who have signed: Antigua and Barbuda, Belize, Dominica, Grenada, Guyana, Jamaica, St. Vincent and the Grenadines, St. Kitts and Nevis, and Lucia. There's no Barbados. States that have ratified: Antigua, Belize, Guyana, St. Vincent and the Grenadines, St. Kitts and Nevis, and St. Lucia. Now, to its credit, the Barbados Association of Journalists and Media Workers, BARJAM, has continuously pressed for FOI ATI legislation. Through BARJAM, we did hear from the Attorney General back in 2019 on this matter. A release from the GIS in 2019 stated that the Attorney General and Minister of Legal Affairs, the Honorable Dale Marshall, made a commitment that the matter would engage government's attention, and a timeline of 1 year was given. And he also said that government had already started to examine what a Freedom of Information bill for Barbados would look like. And that was August 2019. It is important to also say, though, that COVID-19 came. And before that familiar caveat is highlighted, to put things into perspective, let me say, then came COVID. But my point is that we now need to press on, to return to normal, to bring these important matters to the forefront, and a government that wants to bring a cohesiveness around the issues of how people use devices and share information within the context of the advancement of technology could gather greater support for the Cybercrime Bill by following up on the Freedom of Information Act. It projects a willingness to not just hear the people, but to listen and act, and to lead by example in creating an enabling environment for responsible sharing of information. Back to the GIS release, the AG said back in 2019 concerning the FOI and ATI legislation that the process would first require government having to completely transform the way things were done in the public service, particularly how information was documented and other governmental processes. And I would like to think that by now, COVID-19 has sped that up. And I do think that government has shown good intent, if you're honest, and has made some progress in this regard. The AG was quoted as saying, back then, a serious administration needed to have a healthy relationship with the press. What we have to do as an administration is to ensure that we facilitate the dissemination of information to our citizens. When we look at the question of a Freedom of Information Act, it is precisely because we need accurate information to be in the public domain. Secondly, in order to ensure transparency and good governance, citizens have to have almost unfettered access to information. And thirdly, when people in leadership roles understand that there is a mechanism where their actions are exposed and measured in fairly short order, then they have a strong incentive for conducting themselves properly. Mr. Marshall declared noting such matters would exclude those of national security. To facilitate the process, the Attorney General said...
Mr. Green, just need to advise you, you have 1 more minute.
Okay. All right, so to wrap up,
Chairman, may I ask, Mr. Green, can I share his written presentation with us, if he is so minded?
Sure, sure, I definitely will. All right, so to wrap up, let me say this. In modern times, we need to modernize our laws, yes, and our people are expected to accept this and conduct themselves accordingly. And that is why we are debating the cybercrime bill. Likewise, we need to modernize the processes within government that will facilitate how information in the public interest is captured and disseminated. Both go hand in hand to strengthening the values of responsibility, trust, and transparency while truly turning our backs on perception of secrecy, corruption, and unnecessary control of information. Notice I say perception. Especially in the digital age, my final point is that this is a way for us to work together to fight against the enemy of misinformation and disinformation. The media in particular applies skills of verification and other treatment of information as part of its work. And it is now doing so with the same concerns that we all have about the technology. In conclusion, the enactment of the Barbados Cybercrime Bill presents the opportunity for us to reaffirm our commitment to effective communication practices. Let us seize the moment to cultivate a culture of openness, dialogue, and progress, thereby empowering our people to play an active role in shaping our collective future. In so doing, my recommendation to treat the freedom of information, access to information legislation with the same level of seriousness will help us to achieve this. So thank you for the opportunity to present.
Thank you, Mr. Green. You realize, of course, that I gave you some liberty because you spoke mainly on the need for a freedom of information legislation in Barbados. And that is really not our mandate. Our mandate is not to advise on what other pieces of legislation should come before Parliament. We are looking at 2 bills, and neither of them are freedom of information legislation, but I allowed you a bit of width and length in cricketing terms. We have cricketers here on this committee, and but I would want to urge you to make your further appeal for that legislation before other forum or by other means. So before I intervene and engage you, I will allow other members who may wish to do so. Any members? Senator Nichols.
Thank you, Chair. Just a couple of questions for Mr. Green. Good afternoon. Good to see you again. And good luck tomorrow. Thank you. Yeah. You mentioned Trinidad and the, I didn't catch the name of the person who wrote the article about the comments about their consideration of the legislation. But I'm wondering whether or not, are you aware of any challenges to the bill, even at this stage in the Trinidad Parliament? Any legal challenges?
Right, so as I said, so this was an article that was posted back in 2017 by the Center for Law and Democracy. And they emphasize issues with that particular bill at the time, right? Now, my main point there is, obviously, if there are issues that they have with the bill, all right, then at the end of the day, we also have issues with the bill. I wasn't delving into the specifics of it. Nor
I wasn't suggesting that you were. I just trying to understand the point you were making from
Yeah.
how I understand it.
Right.
And I'm aware, I'm not sure if you are, but the Trinidad is the only country within the Commonwealth Caribbean that does not have specific limitations on fundamental rights written into the text of the Constitution.
Okay.
In other words, the rights can appear as if they were absolute. There is no written limitation in the text of the Constitution, whereas in Barbados we will have the constitutional right to freedom of expression in subsection 1, and then the limitations in subsection 2, right? They are not written in a way in which there is any express limitation. So that the way in which in Trinidad and Tobago the constitutional rights are interpreted by the courts is on the broad spectrum of what is reasonably justifiable in a free and democratic society. Whereas the exception in the other parts of the Commonwealth Caribbean would require the challenger to the bill or the legislation when it is passed to come within or to show that the bill goes outside of the exceptions. And then that broad question comes into play. So that I'm just curious as to the criticisms of the bill you said circa 2017, and whether or not there are any, there have been any major challenges to the legislation since then, based on the criticism, because we need to just necessarily separate, in my view, the criticism that a bill might be constitutional as a comment or a legitimate concern by people, as opposed to a ruling in the same way.
Yeah, I take the point, and I note with interest that in that same article, they would have, like I said, deleted an entire section related to the illegal interception of information. I don't know how that's related to what you just said, but we do have that particular section, like I said, in ours. So to the same extent that these pieces of legislation exist elsewhere and would have been reviewed and relooked, is the same extent to which people who are raising concern might have legitimate points to make.
Right. So I'm not sure, you weren't online when Mr. Harper began his presentation?
No.
Because he would have showed us some newspaper headlines or some headlines from various countries around the world. Are you aware of the constitutionality of this bill in its present form? The model bill under the Bucharest Convention is in Jamaica, in Guyana. We are not new here, having been successfully challenged for it being unconstitutional, or more specifically, being in breach of one's freedom of expression.
Very broadly, but like I said, to be honest.
No, are you aware?
Yeah, generally.
Of a court striking down the legislation?
Of the court striking down the legislation?
So I should ask you, are you aware of any legal challenges formally brought before any courts in the region? Say, for example, Trinidad.
No, I'm not.
Right. That's it for no, Chair.
Thank you, Senator Nichols. And just to make one of my 2 points, interventions with you, Mr. Green, to expand at this time on what Senator Nichols has said. Yes, I mean, we've been hearing a lot on the potential of this bill as presently drafted to infringe on the rights of freedom of speech. And I corrected at the beginning, it's not a constitutional right to freedom of speech, as in the United States of America, where, you know, people could call anyone in public office corrupt, they're crook, they're thief, and that is their constitutional right, is a freedom of expression, and there has to be a difference in that regard, and that freedom of expression in terms of our Constitution, Section 20, as Senator Nichols has said, is not a freedom of expression to say whatever you want, say about anybody you want, say anything about their 50-cent prostitute, the thief, the treasury money, and you don't have proof, you can't prove it, it is curtailed like every other provision in that fundamental rights section by the interests of defense, public safety, public order, public morality, public health, you know, and to not to infringe people's privacy rights and the rights to defame people. So I just wanted to clarify that with you in terms of the Constitution.
I hope, sir, that my presentation didn't suggest such, because I didn't make any comment as it relates to encouraging that kind of freedom of expression, especially as it relates to defamation. I think we in the media know all too well the interest around matters relating to defamation, and we deal with it quite regularly. However, there are times when information is within the public's interest, and that's the key or the crux of the matter in terms of the presentation, that information that is relating to the public's interest, that there is a right for the public to know, a right to information, which is also supported, as we know, in the UN regulation. Article 19 supports the right to information and right for people to know. So it is in that regard, in that spirit, that the presentation is made. And I think that we have a situation where the cybercrime bill brings that debate front and center. People are concerned that matters that they want to debate and discuss online, the bill may seem to clamp down on that. Now, what I'm strongly suggesting that we need to have the bill. And I think, for the most part, the bill seeks to ensure that in this present age that we're in, that people conduct themselves online in a way that, you know, we can progress as a society. But as it relates to being able to freely speak and defame people, that's the part there that I think we need to look at. Essentially, then, at the end of the day, I think, and I still am happy to present that, and I understand, Chair, that the committee is not going to look at the Freedom of Information Act, but I wanted to use the opportunity to strongly suggest that that piece of legislation will address the entire spirit of the cybercrime bill and what we're really trying to achieve.
Okay, my second engagement with you would be where you express concern that the bill, some provisions of the bill would curtail the media from, you know, expressing itself and giving information, etc. But at least how I read it, that, you know, some of the provisions of this bill relating to illegal access, Section 4, interfering with computer systems, Section 7, illegal interception of data, Section 8, access with intent to commit an offense, Section 10, and disclosure of access codes, Section 11, are in all those cases an expansion now of the provisions, similar provisions under the Computer Misuse Act, which of course has been enforced since 2005, 19 years ago. And I'm therefore, obviously, the proposed provisions of this bill, as presently drafted, increase the penalties in every case of those 5 sections I've cited. But in the almost 2 decades of the Computer Misuse Act, have your concerns about the restrictions and limitations that these provisions, similar provisions in the Computer Misuse Bill as presently drafted, would carry out on media houses such as yours, would you say that they're justified? Have we seen court cases, case law in Barbados, which have been brought against the media under the Computer Misuse Act that justify the fear that you expressed within your oral presentation?
I can't say that that's the case. What I'm raising is our general issues that the fraternity of media and journalists have cautioned in relation to these types of matters. I can't say that that's the case, but sometimes these things are tested. And I think because of that, we still need to have it as a part of the conversation and concern.
Any other
Yes,
members?
Mr. Chair. Just we come back at Mr. Green. So Mr. Green, you would agree that it is the role of Parliament to pass the laws which provides for the criminalization of criminal activity.
I don't know that I necessarily want to.
No, I just want to, I'm building something here, so I just
Right.
want you, I can adopt the.
Yeah,
format-
because
format.
yeah,
of-
because
of-
within
of-
the
no, no,
within
of
the
Mr.
word,
Thorne, my senior.
yeah, within the you see, criminalizing.
No, but do you agree with that?
That it is the
And it's not a trick question. Actually, we've known each other for a long time.
Right.
So not trying to trick. Yeah? So don't.
I think we have to tread carefully when it comes to criminalizing.
Right, but parliaments will make that judgment.
Yes.
It does it right. And it is the role of the courts to determine whether Parliament has gotten the judgment correct.
Yeah, but in as it
If it's
relates,
not, you agree with that?
that what?
There's a role of the courts to determine whether Parliament has got that judgment correct in terms of balancing the rights and interests of people in the society.
Yeah, but I don't know if I even agree with that.
You don't agree that it's the role of the courts to determine?
No, hold on. Let me finish my point, right? Because
Anthony, I can allow you to finish, but let's have this conversation first because give me a chance to get to see where you're going.
right.
So Parliament passes the law.
But I would like to see where you're going.
Right.
Because your line of questioning is interesting, and I don't want to get trapped. I want to hear your line of thought before I respond.
Anthony, we go back too long for me to try to trick you.
Right.
Right? And I'm not going to try to trick you. If we were on a cricket field, yes. And I didn't have to trick you then.
You mentioned what, on the cricket field? Well, now let's talk about Akaba Drive,
That's one. Trying to create the gap between bad and bad. Don't worry about that.
Okay.
Now, so that Parliament makes a law, right? Whether it is a good law or bad law, it makes a law in its judgment. It goes through a process and there's a debate and the law is passed.
Okay.
Citizens may feel aggrieved by the law and they may bring an action, and it is the role of the court to determine whether or not in the balancing of the rights of citizens, rights under the Constitution, and the freedoms that people enjoy, whether that balance has been struck in the right place. You agree with me?
I agree.
That is principally. And it is also the role of the citizens of the country to agitate and to keep the discussion going as to whether or not both Parliament and the courts have got their respective roles correct. In other words, I mean, the court might determine that this is not a breach of a constitutional right, but that doesn't end the discussion. You agree with me? And all of this is a necessary process, or necessary within the context of a democratic society that we live in. All right? And the media plays a very important role in keeping that discussion going on.
Right.
This is very just generally going.
Yeah.
Because some people may get the view that the law comes and it has to be perfect at the first time, and it will always be perfect, and it will never require adjustment because we can take it and put it on the shelf up on a shining hill, and then if it doesn't meet that level of perfection, then it is a problem to be a law.
I still think, though, in response to that, that in this process, there is, and I suppose this is what we're doing, there's room for hearing the concerns of individuals.
Definitely.
And before we put the law into place, we go back and review if those concerns are legitimate, and we make adjustments where necessary before it is tested, especially when it comes to people having the ability to express themselves.
Well, I can safely tell you, I don't think within, in the foreseeable future, that we should ever fear in this society that expression can be curtailed by this government or the next or anyone under the present arrangements that we have with the Constitution in place. And I always say to others, with the present composition of the Caribbean Court of Justice, which is really basically said that there are certain basic, fundamental anchors that not even Parliament can change. And we have had only recently, for the first time in the history of our democracy, where the Constitution has been amended and the courts for the first time in Barbados have struck it down as unconstitutional, even although it was passed with a two-thirds majority, even Mr. Thorne voted for it that time. So that there's a deep basic structure of the constitutional fabric of the society. And therefore that no matter what law is passed by Parliament, the guardian of those rights is always the courts. And I just want to be able to separate between the agitation for where that balance should be, whether the balance should be in favor of being able to say and operate in cyberspace and do everything that you want to be able to do without oversight, without regulation, without tilting the scales in a way that there's any regulation of that activity, right? I'm not suggesting that that's a free-for-all, but you appreciate that when we do that, we will have a situation then where the persons who don't have genuine interests, legitimate interests, lawful interests, might also operate within that space and cause hurt and destruction. So the balance has to be drawn because we have the freedom, but the laws are there to ensure public health, public safety, public morality, and the public interests are protected. So Parliament passes the law. The courts decide whether Parliament has got that balance correct. But in the society and in part, free speech is critical to democracy. It is the basis on which we exercise. That's not going to go away by just the passing of a law. You agree with me? That can't be threatened by the passing of a law.
I think you're going to have my support there, but you know what will be stronger than even that? Like I said, we are placing the onus on people to get it right. And maybe we should, as it relates to the advancement of technology. But my main point is when you have, I think it was in 2008 that you had a draft legislation of the Freedom of Information Act. I mean, this is what? 18, 19, 20, 21, over 15 years that draft has just sat there. It has to be that burden of creating an environment for how we communicate. And that's how I opened, right? I opened by saying just that. Communication lies at the heart of everything we do as a people. And if you're really serious about what you just said, and I agree, then the government will also take some of that responsibility as well. All right? And it is about the environment, the perception. That's what it's about. So I may agree with you. Some people may agree with you, others wouldn't. Some people may feel the environment is threatened right now in relation to freedom of speech and expression and so forth. My point is really about the access to information and the freedom of information.
Well,
in that
Anthony,
regard.
Anthony, because of our various professions, right? Because I me just draw a recent example. Last year, I represented a lady who spoke on a political platform who was in danger of being disciplined just because she was, and that regulation has been in place for 50, 60 years. Nobody's ever sought to challenge it. And how many public officers would have suffered from being in fear of losing their jobs for even going to a political meeting? And we must not feel that the agitation, the agitation doesn't only have to come by way of bringing a case in court, but it must be a constant vigilance in the society. And not only when government acts, there's a reaction, but we also have to preserve these rights and talk about them and exchange. And so I welcome the discussion on the Freedom of Information Act. And perhaps now is the time to have that other discussion as to how freedom of expression can be enhanced by way of a Freedom of Information Act, because freedom of expression includes, and I don't necessarily agree with the chair, free speech, freedom to communicate ideas, freedom to receive information as well. All of that is part of freedom of expression as defined in Section 20 of the Constitution. So that this process is good, is necessary. But I just wanted to know where you were in terms of the spectrum as to whether or not every time legislation comes up to protect a legitimate aim, because at the end of the day, if this were tested, proportionality is the basis on which the court will determine whether this is constitutional or not. Is this the only means to achieve these objectives? Are there legitimate objectives that the Parliament has in mind by passing this legislation? Are the means designed to meet those objectives fair? And has the balance been struck right? That's basically the test of proportionality, right? What is reasonably justifiable in a free and democratic society, because we know there are constraints, but they can't be too far on the other side now to restrict freedom. Thanks, Anthony.
Sure, thank you.
Just a very short intervention.
Honorable
I'm not going to
Opposition
quarrel
Leader.
with you, Mr. Green. I'm not intending to quarrel with you at all. Do I understand you to be articulating reservations about the cybercrime bill?
My reservation.
No, I'm going to ask again.
Yes
or no. Do I understand you?
My reservation. Hold on.
That's a yes or no.
In all
I'm going
fairness.
to go to the second question.
No, but in all fairness, though, I really did not come, as I said in the beginning, prepared to speak about the content of the actual
cybercrime.
Yeah, because of the limited time.
Right, but do you have reservations about it?
But yes.
Right.
Right.
Let's go to the second question then. You have reservations about it. You speak on behalf of your media house, that's Starcom, isn't it?
That's right, Starcom Network.
Right. Do you speak on behalf of the entire media, or just Starcom?
Well, as a media practitioner, I'm sure that there will be concerns that they will have.
Right, because you have spoken to other heads of the other media houses. You don't mind saying that?
Where are you going?
To the next question, but after you answer this one. No, this is a free environment.
No,
Don't be afraid of Mr. Nichols, of Senator Nichols.
Yeah, I realize that. I realize that.
No.
We've had some discussion.
You confess that you spoke right. You have spoken to the other heads of the media.
I haven't spoken to the head specifically.
Not specific.
But there is general conversation.
Don't worry about the general.
Yes.
You have had conversations with other heads of other media houses about this cybercrime legislation.
Not if you put it that pointedly, no.
You haven't discussed it with them at all?
Not other heads of
other people in the other media houses.
Yes.
Right.
Yes,
you have had discussions with them. These are very simple questions. Eh?
Yeah, but they were pointed questions too.
Well, simple questions tend to be pointed. Yeah. And they have similar reservations that you have expressed there today, don't they?
I can't tell you that we've gone together and agreed that we have these particular reservations that we're bringing to the table.
Not the particular reservations. What I'm asking you, you've had discussions with other personnel from other media houses. And all I'm asking you is if there is general discontent or general reservation about the content of?
I think the media
Right.
has been more focused more than anything else on facilitating the national discourse. So I can't tell you that we as media houses are necessarily bringing any particular reservation about this type of crime bill. We've been more interested in making sure that we facilitate the discussion and
Right.
impartially
Oh,
so.
I see. So that when you say that you have reservations, it's Mr. Anthony Green as head of STARCOM that holds these reservations against the cybercrime bill.
That, and when I say reservations, because we're not going into
Don't be
detail
afraid
here.
of that word.
Yeah, no, it's all right. I'm not
What
afraid
it
of
means
it.
is that you don't agree with everything in the
That's
cybercrime.
right, that's right.
Precisely. Simple question. You don't agree with everything in it.
Yeah.
In other words, you'd like to see some changes.
Yeah,
That's reasonable. That's all, sir.
okay. Well,
Any other members wish to engage Mr. Green? Okay, if not, Mr. Green, we thank you for coming and having a lively discussion. I get the impression you didn't expect to be engaged so thoroughly, but that's what we're about. And like I said, I urge you to take your advocacy for freedom of information legislation where it belongs. You and your fellow media practitioners surely know how to lobby for what you want on that issue, okay?
Yeah,
So
thank you very
sir.
much. Thank you very much, and again, appreciate it.
So you could just, Mr. Clark, remind Mr. Green and Mr. Williams to send their, what they were reading from as well. So Reverend Nichols, we invite you to come to give your oral submission. And Reverend Nichols, you are here pursuant to the invitation by this committee for persons to come and give oral submissions before it. And you have accepted that invitation, so I thank you for so doing. Just want to clear up because I want the record to be clear, sir. You wrote, in your representation to be given an oral presentation, a hearing, that you are His Excellency. And I would first, like I said, for the sake of the records, to tell us how you are now His Excellency.
Would be my pleasure, sir.
Yes, sir.
Let me just say good afternoon, good evening to the members of the committee, and to thank you for the opportunity to make this oral presentation to you this evening. The explanation is not within my 10 minutes, sir, because I have not got it in my speech.
That is not within your 10 minutes. Be setting the record straight
That's
in
fine,
terms
that's
of your
fine.
nomenclature.
In
So this is not
2018
engaging your 10
My
minutes.
10 minutes, okay, fine. In 2018, I was appointed the International Governor of the Academy of Universal Global Peace USA, a CUN affiliate, to Barbados. And the designation I carry in that context is His Excellency. And it's within that context that I operate. That's 30 seconds, right?
Okay. Okay, sir, because you and I go far back,
yeah,
far back. Our families, your aunt was my godmother. So I was wondering this, His Excellency, sir, which I know nothing of. So you have 10 minutes, sir, maximum, to make whatever case you want to make, for, against, neutral, for either of these two bills, and then afterwards, honorable members of this committee will be given the opportunity to engage you on anything you've said.
Thank you, Mr. Chairman. Let me begin by saying I'm seated here not as a lawyer or a cybercrime expert by any stretch of the imagination, but I do have concerns that I will attempt to address in a broad way this evening, but a little different, I believe, from what you would have expected, because I think there's some that would anticipate I would present certain specifics. But I want, as one of my colleagues say to me, I want to a large degree stay in my lane. And as such, I want to take the opportunity to commend the government, first of all, for seeking to protect the interests and well-being of the citizens of Barbados through this cybercrime bill. Given the recent spate of online incursions into both the private sector and the public sector, it is noteworthy that efforts are being made to protect the country from invasive forms of cybercrime. I am here today, however, as an ambassador for what is considered by many to be the highest form of government known to mankind, and that has gifted this administration with the opportunity to govern the affairs of the people of this country. As such, I fulfill a role that I view beyond that of either Parliament or Senate, and for that matter, beyond this joint committee. A previous presenter was afforded as much as over 2.5 hours, but as you've just heard, the chairman, he's allocated 10 minutes to me. There are a number of messages since this cybercrime bill has made public in engagement I've received regarding concerns and fears of myriads of people pertaining to this bill. It is seen by some as a threat to their fundamental freedoms and liberties, and the fear of simply freedom of speech and expression being targeted for criminalization. It is seen by some as an invasion of their liberties and freedoms and privacy. And yet others, such as spiritual ministers, see some sections of this bill as a threat to their free declaration of the gospel in a country where religious freedom is hailed. Our national anthem encapsulates the point that the Lord has been the people's guide for past 300 years. And it goes on to tell us that he's on the people's side. And as easily as he has granted this administration the opportunity to care for the affairs of the people of Barbados, he can and he will, if forced to, revoke that privilege. And he doesn't need an election to do so. He will hold every one of you in this committee accountable for the decisions that you make that are capable of affecting the lives of people, whether negatively or positively. You should take this committee meeting as a reprieve from him to get this bill right. The voice of the people, we are often told, is the voice of God, and people are speaking. By the same token, I wish to remind everyone that freedom is not the right to do what you want, but it is the power to do what you ought. This administration has been elected and by extension employed by the people of Barbados to look after the interests of the people locally, regionally, and internationally. It is therefore necessary for the public to be engaged before decisions that can have a lifetime ramifications on the people be made by any administration. Regrettably, this appears to not have been done in this instance, and so we are here today. Permit me to quote from a speech made by the then leader of the opposition, now Prime Minister, in the lead up to the 2018 general election, and I quote, "Today is about sending a message that the people of Barbados will not allow anybody, neither Labour Party, Barbados Labour Party, Democratic Labour Party, private sector, to intimidate it, not ever again. You have been raised to think for yourself, and you have the right to speak out. And you have the right to speak out without somebody trying to unfair you in this country. So today is equally about reclaiming for Barbadians the right to express themselves in an environment where fear is removed. We do not believe that the charging of a reverend for saying this is the worst government, or threatening businessmen with contracts, or threatening people with jobs, this cannot continue in Barbados of the 21st century. And if ever the time comes that you give us the confidence to lead you, we too must ensure that we never rule a government to unfair or cause fear in this country. This is the solemn promise of the Barbados Labour Party." End of quote. A solemn promise can almost be equated to a spiritual statement. It's as serious a statement as you can possibly make, such as when you stood taking your vows at the altar when you got married. A solemn promise was made, and this administration was elected based on that solemn promise. And there is an applicable biblical verse that cautions, even warns us, not to make vows that we do not intend to keep, for God considers such persons to be fools. I'm sure that no one seated in this honorable chamber wishes to have the highest power we know of consider us to be fools. I could inundate you with a myriad of international documents speaking to the need to proceed with discretion and care as it relates to the implementation of the cybercrime legislation as guided, for example, by the Budapest Convention, or extracts from the United Nations Charter on Human Rights that speak to the protection of the right to freedom of expression, which, for the sake of some present, includes freedom of speech. Or references to the matters of proportionality as expressed under the European Convention of Human Rights, the International Covenant on Civil and Political Rights, and other applicable international human rights instruments. There are more questions than there are answers. Where are the safeguards and conditions also included in the Cybercrime Convention, in the Cybercrime Bill before us now in Barbados? Why are sections of the bill seeking to criminalize the Barbadian public rather than ensure the safeguards and conditions identified by the Cybercrime Convention? There's much more that I can say regarding this bill, but the allotted time, sir, does not permit me to do so. I am, however, confident, especially having listened to my previous, the speaker that preceded me, I'm confident that other presenters will address those areas of concern specifically. But before I conclude, let me be clear. Citizens are not against this bill in its totality, but only against certain sections such as found between clauses 19 through 23, which either need to be dramatically amended or removed in totality. I dare say that there may be those who might have felt that I should have engaged more of the specific areas of the bill. But my duty as given to me today is to caution you as you make your decisions and the conclusion of these contributions, written or oral. The people are watching you, and they are not afraid. But a higher authority is also watching you. and he will hold you accountable for any action taken to the detriment of the people you represent. Again, thank you for this opportunity, and I pray God's blessings and direction as you deliberate on the contributions that have been made. Whatever you do, know that the time for any theatrics in Barbados is over. This is the Barbados of the 21st century. Thank you.
I thank you, Reverend Nichols, and for your imparting God's guidance on the deliberations of this committee and indeed on the deliberations of the government as a whole. I invite members to engage in discussion with Reverend Nichols if so minded.
Just ask one question. In your presentation, Reverend, you asked the question, I know you say you would not go into any specifics, but you did ask the question, why are sections of the bill seeking to criminalize sections of the Barbadian public? I think that's a statement or a question that requires greater explanation. I mean, yes, you identify sections 19 to 23, but you really need to speak to us as to why you believe that this bill, I don't necessarily support that view, this bill is seeking to criminalize sections of the Barbadian public, and really would want to speak to that section of the Barbadian public that you're referring to, if you don't mind.
Thank you. Well, of course, in the 10 minutes I was allocated, there's a lot more I said as I could say, because I actually brought 2 submissions with me this afternoon. I smiled a little earlier when I heard that a Pentecostal minister was being given 10 minutes to speak. That in itself is a miraculous accomplishment and achievement. Nevertheless, one of the areas deals with the aspect of what could be considered as cyberbullying. And the definition of the word bullying suggests, for example, that the one who is perpetrating the bullying is obviously more powerful. They have a greater, whether it be physical or otherwise, capability. The bill threatens $70,000 fines and up to 7-year incarcerations for cyberbullying, which includes using a computer system to publish, broadcast, or transmit data that is offensive, pornographic, indecent, vulgar, profane, obscene, or, which of course, I think we all agree. I don't think we would disagree with those particular sentiments. Or to cause annoyance, we are looking in section 20. My apologies, section 20. Or to cause annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred, anxiety, or causing substantial emotional distress. Now, I could be standing in my pulpit a Sunday morning preaching a message that does not endorse homosexuality or lesbianism, which the scripture says such were some of us, suggesting change is very possible. And that could cause some humiliation to some. It may cause some intimidation to others. It may cause some annoyance. And what, in its broad expression, the bill is suggesting, and this is why I'm thankful that Mr. Green referenced the perception. The bill is suggesting that if I did that, I could find my actions criminalized. And as far as I'm aware, and I stand to be corrected because I expressed that I am not a lawyer, once that goes on my record, it's on my record. Would I be correct? For those of you who are more knowledgeable. So the expansion of the scope on the meaning of cyberbullying beyond specific definitional terms can lead to challenges in interpretation. A review of what acts are considered to be cyberbullying in various jurisdictions highlights that the Barbados Cybercrime Bill 2024 unnecessarily broadens the scope of acts of cyberbullying. The bill uses language that combines words open to being deemed as vague or overly broad or arbitrary and or subjective and uncertain, and expands the potential reach of the law beyond what is necessary or clear. I must confess that yesterday I had a debate with two of my children on some of these matters. And I found it very interesting, members of the committee, that they were somewhat fully supportive of taking action in this area to some degree, especially when one considers that there are some aspects that, if they are enacted by an individual, can have long-term impacts on a person's ability to be employed, their ability to travel for that matter, their relational components, and other areas. And I thought it rather interesting because I raised a point with them where they felt that it was not the responsibility of the law to police their children, but the parents. And that if an act, of course, I believe there is a limitation in terms of legal action that can be taken against a minor. And in the absence of that, the action I would expect to be taken against the adult. And they felt that that, to some degree, in some instances, was in place because some adults just do not monitor what their children are doing. And so, as you know, I believe it's right that around 33% of the activity on the internet today through social media is done by young people. And a lot of that aspect of cyberbullying occurs on the internet. And in one instance, I remember in the United States actually led to the death of a child. And that is just one specific area. There's some others that we can touch on.
Reverend Nichols, I have absolutely no intention of getting into any debate with you on religion. You would say I'm not qualified to do so, just like how you freely admitted you're not qualified in law. But under Section 21 of our Constitution, of course, not Section 21, freedom of conscience 1. Well, you have freedom of assembly under Section 21 and association, freedom of conscience, Section 19, which speaks towards freedom of thought and of religion, etc. And of course, it's your freedom of religious expression to condemn homosexuality in every form, and you ground biblical context in that. Others think otherwise. And I don't know that this bill, as presently drafted, is going to curtail you from what you have been doing, you and some of your fellow colleague Pentecostal associates. But surely, I have to ask you, if you were to go, say, on the pulpit next week, Sunday, I hate homosexuals. I feel that all of them should be killed. Kill all homosexuals. Do you think that you have the right to say so? Because you have a constitutional right to freedom of conscience and freedom of association and assembly. Because you don't agree with homosexuality, that you can, within the context of cybercrime bill, right now, post on a computer that all homosexuals, practicing and otherwise, closet, open, whatever, should be killed. They have no right to be living in this country. They are an abomination in the eyes of the Lord. You feel you have the right to say so?
Mr. Chairman, I believe the Budapest Convention addresses matters of xenophobia. And that is from that perspective. But since you're asking me the personal question, that would be a betrayal of what I believe. When one considers, as I mentioned a moment ago, there's actually a biblical verse that references the fact that such were some of us. But we have been washed, we have been justified, we have been sanctified. So for me to stand in my pulpit and promote hatred of any entity, whether it be persons of gender, race, color, or otherwise, is inconsistent with my faith. I deal with a Lord who came into this world because he loved. However, it can often be seen that when one is objectional to a matter, that they automatically hate. And that is not necessarily the case. We can disagree, but our disagreement does not necessarily mean I don't like you or I hate you. I disagree with your view on freedom of speech and freedom of expression, but my relationship with you will not change. And so I have to be committed primarily because as I sat here, I said to you and to the committee, I sit here as an ambassador for the highest government that we know of. And I am committed to that government. And incidentally, I am not speaking on the behalf of the Pentecostals or the Pentecostal Assembly or any other religious denomination in Barbados. So I would be betraying my faith if I was to make a comment like that.
Any other, Senator
Mr.
Nichols?
Chairman, yeah, I would like to congratulate Reverend Nichols for those honorable sentiments just expressed. I wasn't sure, Chair, if your off-the-wall example does justice to what is really a really substantive matter. I know sometimes that is really popular discourse goes into the heat of the matter, and we bring extremes. But I would appreciate if Reverend Nichols were to give us some clarity. I know he gave that example, but I am clear in my head that cyberbullying does not prohibit, or the law as intended against cyberbullying does not prohibit any pastor or any person who speaks to matters of conscience in this society, and that were carried live. I tend to do a lot of research, and I have fallen in love with Lord Sumption. Mr. Thorman know him, who was on the United Kingdom Supreme Court recently. Very, very strong advocate for the fact that the entire world wrongly curtailed fundamental rights in the COVID era, and it was overstretched. And not saying that we did it wrong or anything like that, but I do recall him saying recently in one of the lectures at, I believe, at Oxford University, that people should have the right to say things that are objectionable. People should have the right to say things that are abhorrent. And you can't silence somebody just because you find what they're saying objectionable or abhorrent. We have traditionally drawn the line, I'm just paraphrasing from him, that where that abhorrent, objectionable statement is likely to cause danger to life and limb. That is where the law has necessarily drawn the line. But we are to be careful that we are not in a rush to silence all speech just because we do not like the content of that speech. And again, I want to assure you, and I think you know me long enough and know me well, I can't see any court in Barbados of which we are under its jurisdiction, before Apex Court being the Caribbean Court of Justice, that would allow any state under its jurisdiction, any government, to pass a law that will do those things that you have so legitimately brought to our attention and concern. And I have said in the first meeting that we've had, the vague language that the bills are being accused of is something that we have to look at. And I not necessarily feel that we could throw the baby with the bathwater, because I I had a conversation with a schoolmate of mine who is in the security system regionally. And I made that comment here. The level of interference with children, and those of us who are in the legal profession, and you and the counsel, if Bajans knew the level of interference with by adults or children and the exploitation on the internet that goes on in this country, it would be shocking, right? And as a parent, I feel that as I said to the previous speaker, Parliament has to pass the laws and we have to debate them, and these sessions are part of the new structure going forward in the Republic, yes. And we have to debate these in joint select committees, invite the public to comment as the bills are going through the parliamentary processes, yes. It is going to be a messy exercise, but let us not hate one another in the argumentation of the various views that have to contend in a democracy. We have to tolerate views that are not in concert with our feelings. And why? Because the minority in the society live in the society and they enjoy the rights as well. And it ain't the majority who get to say what the rights are. It is the benefit for all in the society, even those who are on the fringes of the society. And we have come too far out of those fringes. When all of us may have in times in the past, may not have had the right to be in this building, in this room, at this time, having a say on national issues. Certainly 60, 70, 80 years ago, it would have been unheard of. So that we need to understand and appreciate that not everyone is going to share our views. And we've got to accept criticism in any context. But at the same time, that doesn't mean that it is a Wild West, is a license for all. I am aware, and it is my last comment, I said this before, Chair, but I said it for the benefit of Reverend Nichols, of suspected suicide by way of cyberbullying going on in Barbados last year, where it was very, very prevalent. Suspected. Not for the reasons my friend may suggest otherwise, but this is something that concerns me as a parent. So let us engage, let us get this process right. And the bill will not be perfect the first time, but at the same time, there are means of moving it to a more perfect balance. Thank you. So I just wanted to share that with you, Reverend Nichols. Thanks.
Honorable Opposition Leader.
Thank you very much, Mr. Chairman. Reverend Nichols, immediately preceding your appearance was the head of a very significant media organization in Barbados. And you are, well, we can call him a leader in the media, and you're a leader in the church. And those are two very significant social institutions, if you don't mind me referring to the church as a social institution, which it is. And there are reservations coming from both of you. And I would take it that his views and your views are representative of the institutions from which you come. And I wonder if the government and this parliament would wish to ignore the reservations expressed by those two very, very significant social institutions. I'm not going to make a speech, though. I've said elsewhere, and I'll say it here, that not every aspect of legislation can be condemned. Not every aspect can be condemned. And when you find your significant social institutions rejecting what Parliament is doing, simultaneously, if you find that there's a time at which these institutions, you're with me, Pastor? Yes. One begins to wonder if it is not a question of trust. while we say that not every aspect of legislation is subject to condemnation, yet you hear the condemnation from these two very, very significant institutions. That is my question to you, is the question of a lack of trust a part of your objection? And that's not a long hop in case you play cricket.
Thank you for the observation of the question. Since this pandemic has begun, that we have just passed through, the matter of trust of governments globally has been an issue for every single citizen. When we began this pandemic, we were told that much of what highly expert, highly reputable professional individuals expressed concerning the pandemic was misinformation and false information. That was equally applied to the treatments that were mandated by governments. Where today, just today, AstraZeneca has admitted finally that their treatment has serious side effects. We were saying that from the beginning. I remember watching an interview with an administrative individual of a particular country, which I will not reference, in which they told the interviewer, we need to control the information that is going out, when the persons who were promoting misinformation and false information were governments and the mainstream media. And I make no apologies when I say that there are certain international agencies, again, which I will respect, that are complicit in that action. The European Union has established a committee specifically to investigate the pandemic and the after effects of the treatments that has proven that every single thing that was said prior to, by the very man that mandated and brought out the treatment itself, was correct. And so as a result of all of that, when you put all of that together for the citizens of a country, governments, period, have lost the trust of their citizens. That is not in doubt. If you go to Spain, if you go to Italy, if you go to the United Kingdom, if you go to the United States, if you go to Australia, if you go to New Zealand, if you come to Barbados, you find that trust is at a very low level. Now, from a ministerial standpoint, trust is an extremely difficult thing to repair once violated. And it takes time. And it takes admission of failure in order to begin that process. The previous contributor mentioned the matter of communication. Many years ago, I was sitting in a marriage seminar in which the minister spoke of the fact that communication was the roof of the marriage. And in truth and in fact, in any relationship, communication is key. And when communication is found not to be true, you have a major crisis on your hand at every relational level. And that is the problem we have had over the last 3 to 4 years. It is known beyond all shadow of a doubt. The Prime Minister of Canada is currently facing serious legal ramifications as a result of his autocratic mandates in Canada. It is there for the whole world to see. And so as a result of that, it has had that, I don't know if you can call it trickle-down effect, where people simply now don't trust. If you ask me how a government can repair that, it has to start to be transparent.
No, I'm not asking.
You're not asking me that?
No.
So you want me to hold on that one?
Yeah.
I make that a part of my campaign.
Reverend Nichols, we're here to talk on cybercrime
Sir,
bill.
please.
So I want you, if you...
He did ask
This
me on
is
the
not
matter
free
of
fall.
trust.
No, so if you don't
Yes,
have
sir.
anything
Yes,
else
sir.
further on the
Yes, sir.
bill.
No, sir, I don't. I was just
Okay,
responding
sir.
to your committee members'
All
questions,
right.
sir.
Well, we thank you. We thank you for your
Thank you very much.
contribution this afternoon
Yes,
and for accepting our invitation.
thank you.
All right.
And I thank you for granting me the honor and privilege, sir. Thank you, and thank you, committee.
Okay then, sir. Yeah, I would want to propose we go through. Mr. Stewart has been here from the beginning, waiting patiently. We now invite you to come forward, sir, and give your oral presentation. And, right. Reverend Nichols, of course, you are free to submit your written, what you were reading to the committee, all right? Okay, sir. Mr. Stewart. Mr. Stewart, welcome this afternoon. You were here from the beginning. You heard it all, so I don't need to repeat to you the rules of engagement for you. And you have your laptop. You're free, of course, whatever you have, you know, in writing, even though it's an oral submission, you're free to present it to the committee. In fact, I would advise you to present it to the committee. I know whether you should submit a written presentation in addition to oral with the subject of debate and some concern. And you did say that you would be willing to submit whatever you say in writing. So I invite you to, if you wish. Okay? So 10 minutes, sir.
Before I start, it's my time. I just wanted to say good evening to you, Mr. Chair. Good evening to the entire committee, the leader of the opposition, and to the members of both houses. And good afternoon to all Barbadians and those, to those persons who are watching. My name is Kimar Stewart. I was invited as an individual. So I am here to represent myself as in an individual capacity. However, I will state for the record, in my professional capacity, that I am a research fellow, a non-resident research fellow at the Caribbean Progress Studies Institute. However, the views this evening are mine and not that of the Institute. First observation, and I'm quoting from the bill, specifically Part 3, which deals with investigation and enforcement. I'm going to reference some words that are in the legislation: insult, embarrassment, humiliation, and I'm going to say that it is my perception that those words are very emotive, and with all good intention, you can post something on social media, well-intentioned, but cause the same effect as though you did it unintentionally with the aim of being reckless. So then who's to determine if you're punishable by the court of law? Second, is my concern that this bill empowers the police force of this country with extraordinary powers. And I say that because when you speak about search and seizure, or the section that deals with search and seizure specifically, it says here, and again, I'm reading from the legislation, nothing that I would have prepared or anything. It says, where a judge or a magistrate is satisfied on information on oath given by a police officer, there are reasonable grounds for suspecting that an offense has been, is being, or about to be committed in any place, and that there's evidence that such an offense is being again, or is about to be committed. My criticism there would be, how would the police know that a crime is about to be committed unless the police were indeed actively monitoring the citizens of Barbados? My next question would be, if indeed the police are the ones to oversee or has the authority to execute the offenses in the bill, what resources do we have in terms of a cybercrime unit to be able to man the offenses in the bill? I heard earlier by a presenter that the bill is likely to cause a ripple effect in terms of the numerous amount of persons that could be potentially held liable. So do we have the resources within the police force in terms of staff, qualifications, and otherwise that would equip them to be able to carry out the requirements of the bill? My next observation here would be, why only the police force and not the Barbados Defense Force? Outside of that, you have, in other larger countries, they have security agencies or private security agencies. In this specific legislation, it speaks to an appointed person, and this appointed person could be, what was the word I'm looking for? Empowered or imbued by the Commissioner of Police. So either the police himself or somebody who has knowledge of a computer system or otherwise that they could instruct to assist. So, prime example, we had a situation in Barbados where we had a former Commissioner of Police of Barbados who has specific skills. And it was public knowledge, right? It was public knowledge that a former Commissioner of Police of Barbados was indeed sent on retirement based off recommendations from the Police Service Commission, right? Now, I will not enter into the record the specifics of the charge. However, it relates back to my original question of actively monitoring Barbadians and internet traffic. And that includes all types of traffic, phone logs, pictures. In the bill specifically, it empowers the police to engage persons who have the necessary equipment to do decryption. So on WhatsApp, one of the most important or attractive features of WhatsApp is security, that you're not able to decrypt my messages, and that's one of the benefits of having WhatsApp. Now, if a country is attempting to bypass a big tech firm, because WhatsApp is no small firm, you are attempting to bypass the security features of a large tech firm that's not based in Barbados. You're looking for legal trouble, right? So we speak about that, and it's going international because the next part of my presentation deals with the Mutual Assistance Bill. Now, that bill originated from the 1980 Mutual Assistance Act to deal with criminal matters. And the amendments being discussed here today, deals with mutual assistance as it relates to computer-related crimes, right? Before, the application of that bill spoke specifically to Commonwealth countries, countries that were signed on to the United Nations War on Drugs and Crime. And as of late, the new amendment says, with any other country that has signed on to the Budapest Convention. Right? So what is so special about these additional countries that will be added to the list, where information sharing will be occurring between government to government, and in the bill, there are clauses which speaks to confidentiality of requests between the two countries. Right? Now, the esteemed gentleman on my right and immediate on my left, they're all politically affiliated persons. And in the bill, the mutual, it speaks specifically to crimes of a political nature, and it excludes, and it lists the crimes that will not be considered to be a political crime. So why not create a section in the cybercrime bill which speaks specifically about criticisms of public officials and what is allowed from what is not allowed, to give the public a sense of confidence that public actors and public officials are not abusing state power to shield themselves from criticism. And they say that in the context that we have a 29-1 in the House. Before it was 30-11 twice. So how are we as a public to perceive a state having a lopsided and imbalance, a serious imbalance of power, and then you're attempting to criminalize free speech in a way where the public, the voting estate now, which is not elected, you want to regulate their speech. But parliamentarians have covered in parliamentary privilege, meaning that any of the gentlemen on my left or my right could get on the floor of Parliament and criticize, insult, embarrass, do whatever. I have parliamentary coverage, but I don't. And you want area that I have a freedom of expression, which is social media, then you attempt to regulate it and over-regulate it to the point that you have actually gone past the security measures that the big tech firms, the same persons who made the apps that we use, you want to over-regulate it more than them, right? So those are my general concerns there. I want to come to the end of my presentation soon because I don't want to go extensively, but the last part deals with the ability of, this is 25 now, section 25, because I think I deal with the encryption information and allowing persons who would decrypt data. But then it says record of seized data to be provided to owner. It says where a computer system or computer data has been removed or rendered inaccessible to the owner, and the police under the bill has the power to render your devices that they confiscate inaccessible to you, right? It is saying here that the person who has control of the system following a search or seizure under section 23, the person who made the search shall, and at the time of the search as soon as practicable after the search, make a list of what has been seized or rendered inaccessible with the date and time of seizure, and give a copy of that list to the owner of that data. But then in the next breath, it says that the police, under subsection 3, a police officer or an approved person may refuse to, again, approved person may refuse to give access to or provide copies of that computer data referred to in subsection 2 if he has reasonable grounds for believing that giving access or providing the copies would be prejudice the situation, the investigation, it would prejudice the investigation in connection with what the search and the seizure was about, and 2, another investigation connected to the original investigation in respect of the search and seizure, which means that if you take away my devices in a search and seizure, and I'm cleared, if a police decides to get overly emotional and petty, he could say that he's keeping my devices and this law allows him to do it without recourse or without stipulation, saying to the police how long you could keep my devices for, the same way you would treat a person or individual who comes into contact with the law. There's a set time that you can keep an individual in a police station without formally charging the person or committing them to be answerable to the magistrate court or whatever court there is. So it should be, the same should be with this. It says here that if they believe any other criminal proceedings,
Mr. Stewart,
yes, please.
one more minute.
Yes, it says here that if they believe any other criminal proceedings or that may be brought in relation to any investigation. So my question is, if you believe that the first charge was not, you were not successful, and you go back to the drawing board and you believe you want to build another case against me, you continue to keep my devices and pass laws to preserve my data that I can't even swipe or clean my own property that I bought with my own money that had nothing to do with the state, but it was a private purchase, and the state of a country should not be depriving the citizens of the private property in that other phone. And if the government wants to engage apps and traffic data and web data, the best thing to do would be to engage the big tech firms like WhatsApp, Facebook, Telegram, whatever, as opposed to overreach as it relates to empowering the police with extraordinary powers for a job that we don't know if they have the requisite knowledge, skills, or experience to handle. Thank you very much.
Thank you, Mr. Stewart, and we now invite committee members to, if they wish to engage you. Okay, if none yet, Mr. Stewart, I made some notes. Section 19.3. And, you know, you had concerns about that section saying that, well, effectively, and correct me if I have misinterpreted you, that, you know, you should be allowed to ridicule a person, embarrass them on social media, and you might do that, you know, with intention or without intention, either way, and find yourself subject to the criminal law. Am I interpreting you correctly?
No, you are not.
No, so explain, clarify what you said there on those issues.
And
when you spoke about ridicule and embarrassment.
In your well-intentioned post, without malice, you can cause humiliation, embarrassment, or any of the other emotional words that were used with a well-intentioned post. That may be true, right? But it causes the same effect as though you did it with reckless intention. So who's to say, or who can speak to my intent for posting it when I tell you it was good, but you trying to suggest that it was bad, or I told you it was good. So then I have to come to court to prove that my intention indeed was not sinister, but more positive. That's my interjection.
All right, but have you read section 19.5? Have you fully read the section, sir? Because 3 says whether you've made this post to cause which causes embarrassment or ridicule. But you don't care whether it's true or false. But section 19.5 gives you defenses. No, I mean, you may. So in other words, if it is true, you can prove it is true, you get off. But suppose someone, because they don't like Mr. Keymas Stewart for whatever reason, or Mr. Edmund Hinkson, because I'm not personalizing it, and because of that, to get at you or Edmund Hinkson, they say something bad about your mother or my mother. They're prostitutes. To get at us, you or me. They can't prove that that is true. And to use your words, well, the intention, I mean, they couldn't care less about the intention, whether it's true or false. Are you saying that Keymas Stewart, his mother, Edmund Hinkson, his mother, should have no redress, should not go and make a complaint to the police, but this person X, for whatever reason, political, otherwise, has said that my mother, or in mother's case, I am a prostitute. It is not true. Are you saying they should have no redress? The police should say, man, too bad. A person could say anything they want about you. Maybe just because, what did you say? Because they're a public figure. Because I'm a member of parliament, because you're a public figure of sorts, a former general secretary of the Democratic Labour Party. Person should be free to say anything about you or your mother. And there's absolutely no truth in it, just to embarrass you or ridicule you. Are you saying that that is how the laws of Barbados should operate, sir? And would you be happy in that situation that you, your mother, or in my case, Edmund Hinkson, my mother, has no legal redress whatsoever? And the person should be free merrily to go along to say that about your mother, my mother. And obviously, we know the situation is forwarded many times. The whole goes out to the whole world repeating it, repeating this falsehood, time and time again. just to embarrass you because you are a public figure of some sorts, or me because I'm a member of parliament.
Your interpretation and your examples, I mean, it will invoke some emotion, a lot of emotion, because you're speaking about a female. That's my queen, my mother, you know? And I'm assuming your mother will be your queen, right? So it will invoke an emotional response at first. However, there's not an emotional place. I started by saying that those words of humiliation, embarrassment were emotional words, right? Secondly, laws of this country under the Defamation Act provides coverage already as it relates to those examples you just gave. So it wouldn't fly, right? So there's no need to overly regulate in this, because let's be honest, that comment can nowhere be taken in kind spirit at all, whatsoever. Any comment, right, like that. So as a police officer, right, a police officer fresh out of school, still very young, masculine, aggressive, very interested in proving to his superiors that he can make it up the ranks, you know? He has to sit and determine for himself if this statement that he's looking at, if it merits him making an approach to go convince the magistrate to get a warrant to come and charge you, right? And this police officer is looking at this statement about my mother. He has to consult with his superiors before he does anything. My question there would be, right, because not to drift too far from the point, my answer to you would have been, no, I would not let something like that to happen. However, if a parliamentarian is afforded free speech with parliamentary privilege and coverage, I'm saying that the public should be afforded that same right within measure. However, if you want to regulate the public, you have to regulate yourself. And this is where I agree with Mr. Green from Starcom, that a Freedom of Information Act should be on the table as opposed to a bill to...
But Mr. Stroke, we're not talking about freedom of information legislation.
Yeah, but you gotta give to get
I need to be clear, sir. I need to be clear. Do you accept that Section 19.5 provides a defense? That if what you say is true, it is public, in public interest to say so, you have a defense. Whether you already have defamation legislation which provides a defense or not, do you accept that those defenses, truth, comment, triviality, privilege, absolute qualified privilege, provide a defense to what somebody says about you, or the examples I gave, your mother, my mother, even if they embarrass you, your mother, my mother, myself, do you accept that there is a defense and that somebody who says that is covered?
I do not, I'm not sure the way you crafted it. And going back to the example of the police officer, that young, masculine, aggressive police officer has to determine, hold on, has to determine, first things and foremost, if an offense has been committed, right? Based off the legislation, if an offense has been committed, and if indeed that the matter is trivial, as you said, the matter is truth, as you said, and it speaks here provided under the Defamation Act. If the Defamation Act covers your question, right, then the Defamation Act stays, and the Defamation Act will be my point of reference as well. However, when you go much further than that, outside of the scope of what's provided, right, and it's true, if I speak the truth, I should not be charged or it should not be prosecuted, it should not be harassed in any way, as long as what I am saying is factual and truth, and I can back up my statements with written or video evidence.
Yes, and where in this section that you have quoted does it say otherwise? Since the defamation defenses apply to this section, where in this section that you have spoken about, is it contradicting what you just said?
If it contradicts what you just said,
Yeah.
yes, the
Where
legislation is
if
very
you speak,
contradictory,
where
yes.
if you speak the truth, you don't get off.
You said it, and you quoted from the legislation. If you post this video, believing it to be, whether you know if it's true or not, it is written in legislation. I didn't want to go back specifically to quote it, because I don't want to paraphrase, Mr. Chairman. So let me capture it here, please. I think it was under the cyber bullying section, maybe, where it speaks to being true or not. Right, sorry.
Yeah, you have it there, if
I'm
not?
trying to find it, but it's right here.
Showing cyberbullying section 20. Because we were talking about section 19, Mr. Stewart, and you move on now to 20. So, like you can see that what I've said, you have no answer to, because you now move on to cyberbullying. So let me hear what you're going to tell me about cyberbullying now.
But I have not moved on. The legislation, all of these are offenses. So one offense for me, at the end of the day, is offense, right? So you got to face the same punishment, maybe a little more money, a little less money in some instances, but it's still an offense. But I want to take the specific reference in the legislation which says, if you post this thing believing it to be true, without knowledge of if it's true, right. It says here at section 19, Part 3, a person who intentionally uses a computer system to disseminate any images or words, not caring whether they are true or false, and causes or is likely to cause or subject a person to ridicule, contempt, or embarrassment, is guilty of an offense and is liable on summary conviction to a fine of $70,000 or to imprisonment for a term of 7 years or both. So if I go by your reference, you're saying to me that only this specific section, which is section 19, right? Only that specific section, if I publish something, whether true or not, I can only be charged under the offenses specifically listed under section 19. Is that what you're saying?
But you have come to tell me, sir. What I'm saying is that I see in section 19.5 a defense. I'm not saying you can't be charged. You know, a lot of people are charged and they're found not guilty. But section 19.5 protects you, doesn't it?
So if I speak the truth, right? If I speak the truth in the first place, then I can come back with the truth again as a defense. But why do I have to go through the public ridicule, right? Remember, why do I have to go through the public ridicule for speaking the truth in the first place, that I can be charged, that a police officer can take it upon himself to come to my house, seize my laptop, my computer, my devices. I'm taken to a police station. Bear in mind, I have not spoken yet, you know, as the police engage you. You have to go to court, spend money, hire a lawyer, do all of these things to prove.
Mr. Stewart, we don't live in a perfect world, sir. We don't live in a perfect world. Anyone, we're all men on this committee, and you're a man. You know very well, sir, that tonight, someone can lay a charge against us, Sexual assault, for example. So what are you saying? What are you telling us here?
Well,
It may not be true.
Right.
Police come for you based on that allegation. So what is the difference between that and this, sir? I really don't get you.
Well, let me give you an example that's close to home, but I will not speak because of sub judice, and so I won't speak to details. But let's just say a scenario occurred, sexual assault, as you said, and this person happens to carry a public position, right? I saw in real time and real life where information was put on the internet purporting to be information originating from the Barbados Police Service, right? Purporting to be. Now, whether this information was true or not, the facts were put out there, right? This person has to go through the court. Wait, let me say one thing.
As you said, subjudicate.
Right.
But
I'm not speaking,
you're essentially agreeing with me.
No, I am essentially saying, right, that if this person has to go through a public ridicule based off a false allegation, right, false allegation, because it's the police officer who has to lay the charge, so that person has to determine whether or not to proceed after a complaint is laid, I suppose. Nothing like that was said here, right? I suppose. Right? So this person has to go through that scorn and that, if that person is found not guilty, right? If that person is found not guilty, which is the person accused, right? What happens then? What happens then? What happens then? Right? So you're then back to square one where you lost all your public credibility, right? You lost all your public credibility on a false allegation.
Are there any other members who wish to intervene and ask Mr. Stewart anything? Mr. Stewart, you raised one good point. I mean, separate, you asked who will police this in the police force. And again, that isn't the concern you can appreciate of the legislature. I mean, the legislature passes laws. It is up to the police to decide how they now will monitor or implement the law or police, quote unquote, the law. So that can't be a reason for not passing the law. You could appreciate that. I just came back from Trinidad this morning, and when I asked, yes, their police department has a separate cybercrime unit to deal with, not Trinidad, sorry, Guyana. Guyana has passed the law, Trinidad hasn't. And I was told that Guyana has a separate cybercrime unit to, monitor and enforce the law. But that's not Parliament's role. You can see that. Okay? And police excessiveness, you spoke about, that the police, would have the power if they suspect a crime is about to be committed to pursue it. But isn't that so with other laws as well? Can't the police, for example, stop a vehicle tonight that they feel, may have persons in it, occupants in it, who they've received information, maybe going to commit a crime, maybe going to be involved in a drug bust or not? What is so different with the legislative provisions of this bill as drafted to existing law? Yeah.
your first comment about policing, my grave concern there, you said it's not reason not to pass the legislation, but my grave concern stems from the fact that our political system, our Westminster system, and in particularly the Mutual Assistance Act of 1980, names the Attorney General as the central authority as it relates to mutual assistance in criminal matters, right? By nature, the Attorney General, in origin, the Attorney General is a person who first and foremost is a member of a political party, second, a member of Parliament, and then you are elevated to that job based or at the courtesy of the Prime Minister, right? So the Attorney General being the central authority and biased in that he is a politician, a member of a political party, and biased also from the fact that the Prime Minister, who that person serves at their behest, follows something called collective responsibility, right? And upon instruction, the police force can become politicized to the point that it can be used to enact witch hunts on people based off the directives coming from the central authority, right? Second, your next comment, the last comment you said, if you remind me quickly.
Police having the authority to intervene where they suspect a crime may be committed.
Well, yeah.
About to be committed.
Yes, but the example you give is in that of a physical nature. Flesh, blood, we're talking about cyber. Hence the reason it's called the Cyber Crime Bill. And hence the reason it's called the Mutual Assistance for Criminal Offenses as it relates to the computer, right? So how would you know that I am sitting here on my device planning to commit a crime unless you were actively spying or monitoring on my device? So if anybody, any committee member could say, how would you know that a crime is about to be committed on a laptop or a tablet? You have to be seeing it. And if you're not doing the spying yourself, you have to be engaging the service provider like Lime or Digicel or AT&T or some, and there are clauses in this bill which speaks to that. And my fear here is that the telecommunications companies can be intimidated and bullied into sharing the private information of the public based off the structure of our current political system.
Unless there are any other members who wish to intervene with Mr. Stewart. Mr. Stewart, we thank you for your presentation and, pursuant to your request for oral, we thank you for coming.
Yes, thank you very much.
Okay, so this brings us to the end of our public hearings for today. We would invite, the public to leave, and we would just deliberate on a couple matters. So we thank you all. Hmm? Yeah, of course. detain you for a few more minutes to go back to the agenda matters, minutes of our last meeting. Did you get a chance to read them?
Was that minutes be adopted?
Yeah, okay, seconder? Okay, thank you. Any matters arising? So for the record, Senator Gregory Nichols and then MP Peter Phillips, seconded. Matters arising under these minutes? Let me see the agenda. Let me see the agenda. The agenda, yeah. Are you on it? Any matters arising?
Chair, the minutes look very short. They're not a lot extensive minutes. They're 1, 2, 3, 4, 6 items. So we don't matters arising.